Delivery of order, item number 1.
This matter, I would require some more time. On 28th, I will deliver, 28th of January.
No difficulty, my lord. Obliged.
May I please, Your Lordship?
Yes.
Back to Mr. Item number 10, Lordship. Any matter may be taken up after a week.
You have informed the other side.
I have informed the others.
What is your name?
A. Hussain.
Not Mr. A. Hussain, learned counsel for the applicant / appellant who prays for an adjournment on the ground of personal difficulty. He submits that he has informed learned counsel for the respondent regarding his prayer for adjournment, who has no objection to the same. Hence, same is allowed. Let this matter be listed
11th of February.
on 11th of February.
May it please, Your Lordship? I beg to move item number 17 of the hearing list. My lord, we have informed the other side, but the SK Taluk, there is some personal difficulty to the moment. May we adjourn for the next week.
What is your name?
K. Sodial.
Heard Mr. K. A.
Sodial.
Sodial, learned counsel for
SK Talukdar. Respondent number 1.
learned counsel for respondent number 1, who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the respondent number 1. He submits that he has informed the learned counsel for the appellant regarding his prayer for adjournment, who has no objection to the same. Hence, the prayer is allowed. Let this matter be listed 12th of February.
May I please, Lordship? My lord, item number 7, Lordship. I have taken consent from the petitioner, Lordship. I am saying for adjournment of the matter for 2 weeks, Lordship. I have to file APDB. Objection I have to file.
Heard Mr.
Lordship.
M.
I have a similar short prayer, lordship. Matter may be fixed after 10 days, lordship. We have some urgency, lordship.
On 9th, Lordship.
Heard Mr. M.I. Hussain, learned counsel for the respondent, who prays for an adjournment on the ground that he has to file written objection in this case. Mr. What is your name?
You Ghosh on behalf of D. Paul, lordship.
Mr. U. Ghosh, learned counsel for the respondent. Petitioner does not raise any objection. Hence, the prayer is allowed. Let this matter be listed on 11th of February.
Lordship. Obliged.
Obliged.
May I please, my lord? I beg to mention item number 4, my lord. My lord, the brief has been taken from us. I am appearing on behalf of S.R. Gogoi. So we would like to withdraw the Wakalafnama, my lord.
You inform brief has been taken back.
Yes, brief has been taken back, my lord. So we would like to withdraw the Wakalafnama.
Learned. Heard Mr.
C. Sharma.
C. Sharma
Appearing on
submitting on behalf of Mr. S.R. Gogoi, learned counsel for the applicant / petitioner, who submits that in this case, the brief has been taken back by the petitioners from the present set of counsel, and therefore they may be allowed to withdraw the Wakalatnama. The prayer is allowed. Let this matter be listed after 2 weeks without showing the name of Mr. S.R. Gogoi in the cause list as the engaged counsel for the petitioner.
deeply obliged.
Bail hearing the item 3.
May it please, Your Lordship. Lordship, on the last occasion, notices were to be issued to the informant, and scanned copy for the trial court record was called for, my lord.
It has not received, Lordship.
This is for consideration of bail, my lord.
Whether notice has been issued.
Notices were issued, my lord, on the last occasion.
But we have not received any instruction.
You take information. Heard Mr.
J. Singh, my lord.
J. Singh, learned counsel for the petitioner. Also heard Mr. K. Das, learned additional public prosecutor. On perusal of the office note dated 21/2026, it appears that the scanned copy of the trial court records, which was requisition in this case, has have not yet been, has not yet been received. Registry to issue reminder for the same. Stop. Learned additional public prosecutor is requested to take information regarding the fate of notice issued to respondent number 2 through the officer in charge of the jurisdictional police station, and let this court know about the same on the next date fixed. Let this matter be listed on 10th of February.
Additional item 2.
Ma'am, please, Your Lordship. My lord, in this case, whether I could not prepare the case because I was away from Guwahati.
Any objection?
No, your lordship.
Heard
Let it be
Miss,
fixed on next time.
heard
Order
Mr. A.C. Sharma. Learned Senior Counsel assisted by Mr.
DJ Methi.
D.J. Medhi, Learned Counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty. The prayer is not objected to by Learned Counsel for the respondent, Miss, what is the name?
Sharma.
Ms. Jay Sharma, hence same is allowed. Let this matter be listed on
On third.
third
of
of
February.
February.
Obliged.
Order item 5. Interim order personal and continue.
Okay, the interim order, Agora case, no, the interim order shall continue. Yes,
Please, Your Lordship. Lordship, I filed this IA under order 41 rule 27 for adducing additional evidence. Only thing is, Lordship, in the main appeal, service is complete and LCO also received. So this IA may be considered at the time of hearing, Lordship.
I haven't received the copy of the IA yet,
you have not received.
the copy of the IA.
I will send
Okay.
copy, Lordship, today itself.
Heard Mr.
Sure.
R. Sharma, Learned Counsel for the applicant / appellant, who submits that this interlocutory application has been filed by the appellant under order 41 rule 27 for adducing of additional evidence at appellate stage. He submits that since the connected appeal, that is MSC appeal number 980/2018 is ready for hearing, this instant interlocutory application may be taken up for hearing along with the main appeal. Stop. Also heard Mr.
R. Paul,
R.
Yeah.
Paul, Learned Counsel for
respondent number 6.
respondent number 6, and Miss
P. Bora, appearing on behalf of Mr. P. Hazarga, Insurance Company, Bagatagara.
P. Bora, Learned Counsel appearing for the insurance companies. The Learned Counsel for the respondents do not have any objection to the prayer made by the applicant. Hence, same is allowed. This interlocutory application shall be heard together with the connected MSC appeal. The applicant is directed to furnish copy of the interlocutory applications to the Learned Counsel for respondents. You have received? You verify if they have not
Not yet.
received, you list the connected MSC appeal for hearing
26.
on 26th February.
Obliged, Lordship.
And another date, my lord, 27th.
5th of March,
Obliged.
5th of March.
Obliged, Lordship.
My lord, the item number 2, the interim order, first I may continue.
Yes, I have passed that.
Item 6.
May it please your lordship.
No, please, your lordship, my senior counsel is on leg. Kindly take up the matter after some time.
Lordship, Wakala, as per
Yes.
office note, services were.
The name is not mentioned, my senior counsel name is not
Just a
mentioned.
minute.
Appearing,
Yeah.
perhaps appearing.
You are appearing for
For Vikas Ranjan Das.
Sole respondent.
sole respondent.
My senior is on the way.
No, we'll fix it for admission hearing.
Yes, lordship. That may be fixed.
If you are appearing for, why it is fixed for orders today?
On last occasion, notices were. issued.
Notices were issued, okay. This is item number,
6.
your name is not reflected. You have filed wakalatnama, your senior has filed wakalatnama.
Yes, as per I know, but the name is not mentioned.
Okay, heard, Mr. What is your name?
And Pathak.
M. Pathak, learned counsel for the petitioner. Also heard, Miss, what is your name?
Uroy appearing on behalf of PP Medhi,
You, Roy, appearing on behalf of Mr. P.P. Medhi.
Mr. PP
She-
Medhi.
Mr. P.P. Medhi, who submits that they have been engaged by the respondents to appear in this case. Since the appearance of parties is complete, let this matter be listed for admission hearing on 13th of February.
Interim
The
order.
interim order shall continue till next day.
Item number 8.
None has appeared for the petitioner on call. On perusal of the office note dated 21/20/26, it appears that,
এটা maybe pass over time নেই
no, what is your name?
RK Mohan Rao.
Reflect his name.
Actually, Mr. AK Gupta is on under court.
Okay, no, we are passing orders. Mr. R.K. Mohanta appears on behalf of Mr. A.K. Gupta, learned counsel for the petition. On perusal of the office note, it appears that the notices issued to respondent number 6 has returned with postal endorsement, no such person at the given address, so RTS. Stop. As regards other respondents, the service report is awaited. Stop. Learned counsel for the, no, the petitioner is directed to take fresh steps for issuance of notice upon respondent number 6 at his proper address within 7 days from the date of this order, returnable on 19th of February. The registry is directed to place the coastal track consignment report of the notices issued to respondent number 1 to 5 and respondent number 7 on the next date fixed. Let the matter be listed on 19th February. You have to take fresh steps as regards respondent number 6. As regards other respondents, we are directing registry to place the postal track consignment report. 19th February.
Okay.
Item 9.
May it please your lordship, in this case, respondent number 1 and 2 appeared, my lord. And respondent number 3 and 4 already died, my lord, and their legal years are respondent number 1 and 2 already on record, my lord. Therefore, their respondent number 3 and 4 name may be struck off. And in respect to respondent number 5 and 6, they did not contest before the tribunal. Therefore, their name may also be struck out, strike out.
What is this? IA?
I is for delay condonation application.
Okay. Heard Miss S. Roy, learned counsel for the applicant. Though no one has appeared for respondent number 1 and 2. Stop. Learned counsel for the applicant has submitted that the respondent number 3 and 4 have expired. However, their legal representatives,
Or 1 and 2.
however, respondent number 1 and 2 are their legal representative. And therefore, there is no need for substituting their name again. Stop. She further submits that as regards respondent number 5 and 6 are concerned, the said respondent have not contested the matter before the tribunal, and therefore they are not necessary for consideration of this appeal and their names may be struck out. The prayer is allowed. The matter may be listed again in orders column. We will wait for 1 and 2
One, and nine,
on 9th of February in orders column for hearing on delay condemnation application.
Item 11 and 12.
No, please, item 11, Lordship, we have filed our written objection yesterday only. So if Lordship, maybe taken up in next week.
What is item 11?
My lord, I have filed one IA for a withdrawal of the money deposited by the insurance company, my lord. They have challenged the execution, my lord, against the MSCT award. I have filed one execution case, my lord. Again, by challenging that execution case, they have filed this revision petition. This court had stayed the execution subject to payment of 50% before the registry of this honorable court. So I have filed this IA for withdrawal of that amount. my lord.
CRP has been filed for challenging the execution. And this MSC appeal,
MSC appeal, Lordship, the order has, judgment has been challenged in the MSC appeal. Since there
Delay is there.
there are
Delay.
yes.
Delay.
So they have Lordship preferred the execution proceeding. Accordingly, execution proceeding initiated Lordship and our office was also Lordship keep under lock and key. So to open that Lordship, we have filed this review. Accordingly, as per order of this honorable court, we have deposited the amount, but that is not subject to release the Lordship claimant because they are not entitled Lordship. They are not dependent of the deceased person, basically. That is our basic ground of appeal. Lordship. Let it come. with the
okay, let the objection come on record.
Lordship.
Heard Mr. A.K. Gupta, item number
11, my lord.
11. Heard Mr. A.K. Gupta, learned counsel for the applicant. Also heard Mr. J. Kolita, learned counsel for the respondent insurance company, who submits that the insurance company has filed a written objection yesterday and same is not tagged with the case record. He is praised for directing the registry to tag for placing the written objection with the case record and fixing another date for hearing on the interlocutory application. Prayer is allowed.
11th of February.
11th of February. List this matter on 11th. of
11.
Okay.
And
All
what is 12th?
If 12 Lordship, there is stay order is there, that may be continued.
12, the delay has been condoned.
No,
Oh, no, sorry,
No, no.
delay has not been continued, but the respondent has appeared. Lordship.
I, 12 or I. 12 or I লিখিব. Heard Mr. J. Kolita, learned counsel for the applicant. Also, who are the respondents?
Number 7, Lord. That's why insurance company.
Heard Mr. P. J. Burman, learned counsel for respondent number 7.
I'm for 1 and 2, my lord.
And Mr. A. K. Gupta, learned counsel for respondent number 1 and 2. Who are the other respondents?
Respondent, office note, I could not see the office note also.
The office note dated 19/1/2026 shows that AD card issued to respondent number 4 and 5 have returned with signatures of who are 4 and 5. Signatures of one Namita Bora Burua and R. Begum on the said AD card. Who are these?
Look, they both are the drivers, my lord.
That Lordship.
The the
Yeah.
The registry is directed to place the postal track consignment report in respect of notices sent to respondent number 453 and 8 before this court on the next date fixed. Let this matter be listed again on the data sale, 11th of February.
Yes.
Sorry, madam, I could not get the item number 5, madam, very another code, madam. I have been informed, my lordship has fixed the matter for hearing, madam. So my name may be recorded, I am for a claimant respondent, madam.
Item number,
Item 5, madam,
you are for
claimant, madam, 1, 3, and 4.
item number 5. Show the name of Mr.
Sethi.
M. Setia. Learned counsel for respondent number 1, 3, and 4 is present.
Also,
Item 22 from supplementary list. Item 22.
None has appeared for the appellant on call. It appears that by order dated 5/12/2025, the appellants were directed to issue notice to respondent number 11, 13, 17, 18, 20, 22, 24, and 25 by substituted mode by publishing the notice in 2 newspapers. However, on perusal of the office note dated 21/1/2026, it appears that no such steps have been taken by the appellant. The appellant is given one more chance to take the steps for issuance of notice to the aforesaid respondents by substituted mode of publishing the notice in 2 newspapers circulated in the area where the aforesaid respondents are stated to have resided. These steps shall be taken within 15 days from the date of this order. The date of appearance to be mentioned in the said notice shall be February on 27th of February. List accordingly.
Hearing item 13.
May it please your lordship, lordship already heard the matter. Today is fixed for submission of written argument by the insurance company. Already claimant has submitted written argument on the earlier date. I am submitting my written.
You are for insurance company.
Insurance company. Claimant has already submitted the written argument. Let the matter case will be fixed for judgment.
Heard, Miss, what is your name?
E. Sarma.
B. Sharma, learned counsel for the appellant. Also heard Miss S. Roy, learned
Respondent number 3.
learned counsel for respondent number 3 within bracket insurance company. It appears that this matter was substantial. This matter was heard at length by this court on earlier occasion, and the parties were requested to submit their written gist of argument. the when an appellant has not submitted,
On the last occasion. huh? Yo, no, sir, submit ko naman ito. On the last occasion, he told me that he has already submitted. That's the-
there is no indication. DNA. Miss, huh? Miss S. Roy, Learned Counsel for the insurance company, has submitted her written gist of arguments. Learned Counsel for the appellant is requested to do so within a week from the date of this order. Let this matter be listed again, listed again on 30 January 2025.
Item 15.
This matter was partly heard by a lordship, my lord. It is a landlord tenant dispute, my lord.
Where is the tenant?
Well, the tenant should have been here, my lord, but I don't understand why they are not there, but I'll place my arguments, my lord. In the meantime, they'll come, my lord.
You are landlord,
Yes, I'm landlord, my lord. My lord, I have a very limited case.
but in their absence, if we hear how
Yes, my lord.
they will reply to your submissions.
After some time, my lord, because.
Okay,
otherwise-
we'll take it after some time.
Item 16.
None has appeared for the appellant on call. Miss
S. Pal,
S. Paul
appearing on behalf of Mr. B.J. Mukherjee.
has appeared on behalf of Mr. B.J. Mukherjee, Learned Counsel for the respondent. It appears on perusal of the record that on last occasion also the appellant was absent without any steps. And it was indicated in the said order, that is order dated 9/12/2025, that the appellants were granted one more chance. However, today also none has appeared when the matter was called for hearing. Accordingly, this court is left with no other option but to dismiss this regular first appeal for default.
Much obliged, Lord.
Item 18.
Who is for respondents?
Mr. Ms. Chaudhary, Chaudhary is for the respondent.
R.
Chaudhary
R. Chaudhary,
is for the respondent claimant.
it was heard in part by some other court.
Lordship, I think it is not part heard, but it is heard by Honorable Justice P.J.
P.J. Saikia.
Saikia, Lordship. Last time it was heard by.
What is to be done? Both parties were present.
Look, what were present, Lordship, last time. I'm not unaware if it is even kept as a part heard or not.
No, there is no indication, but indication is there that hearing was done.
Yeah, hearing was done, like,
Heard Mr. What is your name?
yeah, actually.
A. Acharya, Learned Counsel for the appellant. None is present for the respondent side. On perusal of the records, it appears that on 2/2/2025, this matter was heard by a coordinate bench of this court. Though the matter is not shown as part heard, however, as none has appeared for the respondent today, this court is inclined to adjourn this matter today. Let this matter be listed again on when?
Plus any convenient date.
12th of February.
12th of May.
12th of February.
Plus.
Item 19 and 20.
Your lordship, the engaged counsel is on legs in another court. May it be heard after some time.
Okay,
Obliged.
after some time.
Item 21.
Where is the appellant? You are appellant?
Yes.
Okay. Then where is the respondent?
Um,
Who is appearing for respondent? N. Alam. What is to be done? You are ready.
My senior is Lexon Civil Court, my lord. A. Biswas also.
Okay. So we'll adjourn this then. Heard Miss M. Das, learned counsel appearing for the appellants. None has appeared for the respondents on call. Learned counsel for the appellant has also prayed for an adjournment on the ground that the senior conducting counsel for the appellant is on legs in some other court. Considering the circumstances, the present matter is adjourned for the day. Let this matter be listed on 5th of March.
My lord, 5th of March.
Any other date?
My lord, oblige me.
Mr. Gupta, you have anything?
Lordship, so far as item number 13 is concerned,
Yes.
I've been directed to file written argument. Other side, file written argument.
Mrs. Roy.
No,
Yes, when will you be filing?
do it.
Your argument, written argument,
Written
13th কি order হয়েছিলে? Next day. কাটি দিও। Miss S. Pal S. Roy has submitted, learned counsel for both the sides have submitted their written arguments. The hearing concluded, judgment reserved.
Lordship.
Will save you. I'll raise again.
Item 19 and 20.
Yes.
Lordship, decision appeal against the judgment passed by the learned member MHT Lordship. We are challenging the quantum of compensation Lordship. In this case, wife and married daughter are claimants, were claimants Lordship. But in this case, victim was stated to be working in an NGO. In an NGO, they did not file any
10 and PAN number details, etc. It is mandatory to have all the PAN, TAN and income tax return. All these were not placed before this, before the tribunal in this case. So they are claiming that 20,000 was monthly income of the victim, and the learned tribunal had accepted the same as 20,000. But in absence of any PAN, TAN, etc., our submission is that these were not valid documents. Lordship may come to page 16, running page 16 of the judgment.
Yes. Yes.
16, paragraph 10. In his cross-examination, PW2 stated that the pending motorcycle, after causing the accident, fell down on the road. PW2 denied the suggestion that driver of the vehicle had no fault. PW2 also denied the suggestion that the accident occurred due to the fault of the deceased. PW2 expressed ignorance whether their committee is registered under section 12A and 80G of income tax or not. PW2 also did not know whether their committee had PAN, TAN or not. PW2 stated that he is also a salaried employee of the society, of the committee. PW2 also stated no professional tax was deducted from their salary. In his cross, PW2 further admitted that he had not brought any attendance register and salary register of their committee. So our submission is that without these vital and mandatory documents which are required under the Income Tax Act, the alleged income shown to be received by the victim is not acceptable. The learned tribunal had accepted it as rupees 20,000 per month. But
No, what was the source of income of the?
of the NGO loss, he was stated to be working as manager of that committee, which is known as Prakitik and Hipu Kalyan Committee, a NGO registered under Societies Act. He is stated to be manager of Prakitik and Hipu Kalyan Committee.
What documents were
They
exhibited to?
exhibited salary certificate. They had exhibited salary certificate.
Exhibited as
Salary
exhibited as exhibit? So the tribunal relied on the salary certificate to assess the income.
Yes, salary certificate.
Salary certificate was exhibited as?
Exhibit number. Exhibit 16, 1 to 18. Lordship, go to page, running page 19, paragraph 17 of the judgment. Exhibit 16, 1 to 18. Running page 19, paragraph 17 of the judgment.
In the judgment, page number 175 to 193, Milord, are the salary slips. If that,
In judgment copy, Lordship, in my appeal memo, it is in page 19, paragraph 17.
16:1 to 16:8.
16, 1 to 18.
You are saying that tribunal was wrong on relying on these
Yes.
documents. Why?
Without
According to you, no Samiti exists.
committee did exist as per registration certificate exhibited. Lordship.
Registration certificate is
Yes,
there.
yes. Registration
So
certificate, but no income tax return is submitted, no PAN number, no TAN number is there, Lordship. So without these mandatory documents, which is required under Income Tax Act for any NGO or any trust, our submission is that this income is shown in the higher side. It is not so. Without income tax return and TAN number, PAN number, these are statutory requirements also to have any NGO or any society, any trust. Income Tax Act specifically mentioned that these are mandatory documents.
under what provision?
That is Lordship, under Income Tax Act, Lordship. For any society or any
Suppose
NGO.
there is a violation, what would be the consequences?
So if there is violation lordship, our submission is that they made this income tax salary certificates lordship later on to show higher income of the employee.
These are fake salary certificate.
So lordship,
Are these fake salary
yes,
certificate?
yes.
Was there any
yes,
suggestion to this regard?
yes, there are suggestion lordship. There are suggestion lordship.
Okay.
Because without income of the society being proved or income of the NGO being proved by legal document, by acceptable legal document like income tax return, so how can we lordship assume that such and such salary were paid to the employees? So inflated salary certificate was issued to the victim and to get higher compensation.
Okay.
And our second ground of appeal is also lordship that being a society or NGO, this job cannot be said to be a permanent one like that government job. So if there is addition of future prospect, in this case, learned tribunal had accepted is at 30%, but it should have been 25% as per university judgment. The societies are not permanent existence, these NGOs. Like government employee, they get full service tenure, but for a society employee, it cannot be said to be a permanent job. So instead of 30% addition in the head of future prospect, it should have been 25%.
Okay.
And another ground lordship we have taken that mother and wife and daughter were claimants in this case, but record shows that only mother was dependent. As because lordship, daughter had died. Daughter had died on 9/8/2020 before the passing of judgment. So at the time of disposal of the case, only one claimant was there, that is wife. And as per decision of this Honorable High Court and also of the Supreme Court lordship, when there is only one claimant, 50% deduction is to be made for living and personal expenses.
From where you are saying that daughter died?
Daughter died, lordship.
Accepted strictly on it.
It
We have
is-
filed a petition to that
Okay.
effect. When during the pendency of the claim petition, daughter has died, there is an order to that effect, lordship.
Daughter died, lordship, in first. Page 12, first line, lordship, judgment. Page 12, first paragraph. There are decisions of this Honorable High Court lordship. When there is only one claimant, deduction is to be made 50%.
Yes.
Lordship had got the judgment also. Page paragraph 15.
paragraph 15 of the judgment also.
Yes.
In other words, therefore, it would be same that while in
Paragraph
paragraph 15, Lordship.
1.5, no evidence.
Lordship. In citation, I have just placed before Lordship.
Oh, yes.
Paragraph 15, Lordship. In other words, therefore, it would be same that while in paragraph 30, the Supreme Court has held that the deduction should be 1/3 grade of dependent family members is 2 to 3, but in paragraph.
So you are relying on Sarla Verma.
Yes, and this is also supported by this Honorable High Court judgment also.
Okay.
There are two judgments in the same line. Same fact. Moreover, Lordship, the daughter was married. The exhibited document, Lordship, in page 277. That is death certificate.
Yes.
Lordship may peruse. In my citation, Lordship, this is in paragraph 9 and in paragraph 13. Same text, Lordship. While there is only one dependent, 50% deduction is now.
Sarla Verma is silent
Solabama is
as to when,
clear. Solabama is very clear, Lordship.
when there is one dependent. How much deductions? Sarla Verma says that 50% is to be deducted only if he is a bachelor.
Specifically says.
Show me.
Lordship, paragraph 30 of Solabama, Lordship.
Yes, read where it is meant.
30, paragraph 30 of Sarla judgment. Lordship has got.
Yes, read.
Thou, in some cases, the deduction to be made towards personnel and living expenses is calculated on the basis of unit indicated in Trilok Chandra. The general practice is to apply standardized deductions. Having considered several subsequent decisions of this court, we are of the view that where the disease was married, the deduction towards personnel and living expenses of the disease should be 1/3. Where the number of dependent family member is 2 to 3. Here it is specifically written that.
No, where it is mentioned that if it is 1, then 50% deduction is to be given.
Lordship, that is the indication, Lordship, because if Lordship, if it were that 50%, 1/3 were directed, were required to be directed, then it would have been Lordship 1 to 3. If family members were 1 to 3, but in this case, it specifically says that 2 to 3. When there is 2 to 3, then 1/3. So when there is only one dependent, it is 50%.
Who says so? Sarla Verma does not say so.
This is Lordship specifically
Implied.
Implied, Lordship. Otherwise, it would not have been written that 2 to 3. It would have been written as 1 to 3. But it is specifically written that 2 to 3, deduction 1/3 and 1/4 when it is 1/4 where number dependent is 4 to 6, and 1/5 when number of dependent is family member exceeds 6. So this implies that only where only one dependent is there, it should be 50%.
Now, who is surviving of the present
Only wife of the victim.
wife?
Yes, and maid daughter was made claimant, but she died during pendency of the case, and the death certificate loss in the LCR it is there, case 277, where it is written that her husband was one Vishal Bhia. So she was married at the time of death. Mother is now claimant Rita Bora, and daughter is already expired, and she was married also as per death certificate. Case 277 of the exhibit of trial court record.
Okay.
So these are the main grounds of our appeal process. And so our prayer is that our appeal may be allowed taking the monthly income of the victim at the lower side.
And there is a another appeal for enhancement.
Yes. From here.
Your objection to that?
Yes, our objection to that is there, Lordship. They are saying that no major contradictions are there in the appeal. That means in the judgment. So their admission is that there are minor discrepancies is there. They have said that in the appeal there is no major.
No, on what basis they are claiming enhancement? Or we'll take it up after he submit.
Yes.
Okay, okay.
The first condition, Doctor, is that when there is specific.
Putul, আৰু এটা MSc আছে জি লগত attach. Yes.
The very first submission is not when there is a clearly mentioned in Sarla Verma judgment, Lord, that the deceased, if it is not married, 50%, married 1/3, Lord. So now implications, my lord, from 1-2 line or sentence, my lord, trying to misconstrue the judgment, my lord.
No, in Sarla Verma's paragraph number 30, it speaks about only 2 to 3, but in para 32, it speaks that if mother is there, so if there is one dependent, 50% is to be deducted.
Lord,
That logic is adopted by the.
Maybe not, but in my humble submission, Lord, say, my case is different. Post facto change in the any circumstances, my lord, will not debar me from claiming. There are settled law, Supreme Court criti judgment is there, lordship, in which it is specifically held. One person died during the pendency of the claim petition. He was entitled to the bills. The Supreme Court says post facto change will not make any impact. But as lordship has seen, my lord, Sarla Verma Jasma, it says specifically, my lord, that if there is a married person, he tends to invest more in himself. My bachelor, married person tends to have some responsibility and he cannot invest that much as much he used to invest, or he can invest even when he was not married. It's a practically written judgment, lordship. No law is involved here. And but that is my first submission that lordship has seen. My main submission would be that post facto change in anything will not debar me from claiming. That is my case, my lord. Now, lordship, in this case, if we have asked for enhancement of compensation, my lord, on 4 grounds. One, my salary certificate shows, my lord, I was getting 5,000 as miscellaneous expenses. That was not included. 2, my lord, that learned tribunal has deducted future income, future interest, my lord. That is not permissible. Third, 6% interest. That is not permissible. Fourth, no loss of consortium was not granted to the person who has died, my lord. Parental consortium was not provided. The daughter, my lord. These are the 4 grounds, my lord. So first, my lord, let us see whether the tribunal was correct in accepting the salary certificate or not, my lord. Lordship can take the TCR, my lord, trial court record. From page 173 onwards.
Yes.
Page 173, will also take a look.
Yes.
It's the appointment letter, my lord.
No, they are objecting only on very limited points that you fail to exhibit PAN card, TAN number, and income tax return.
I did not realize my employer failed to provide these details, lordship. So whether that will be tenable or not, then we can satisfy your lordship, there's settled position of law on that point, my lord. These are the 3 judgments. Supreme Court has settled it long ago, lordship. This is it. Which is urban development.
Yes, what you want?
Paragraph 20 and 21, lordship. It is settled that Motor Vehicle Act is a beneficial piece of legislation, and as such, while dealing with compensation cases, once the actual occurrence of accident has been established, the tribunal role would be to award just and fair compensation as held by this court in so and so. Strict rules of evidence are applicable in a criminal trial or not applicable in a motor accident compensation case. to say the standard of proof to be borne in mind must be the preponderance of probability and not the standard of proof beyond all reasonable doubt, which is followed in criminal cases. In view of the above, we do not agree with the view taken by the High Court while rejecting the salary certificate, Exhibit 19, and payslip of the deceased merely on the ground that the person issuing the aforementioned two documents was not examined before the learned tribunal. The said documents are conclusive proof of the income of the deceased, conclusive proof, and were also corroborating by the statement of the deceased wife, appellant number 1, and his co-worker. As such, the High Court was not justified in assessing the income of the deceased at so and so per month on the basis of minimum wages act. So here, the employer was not examined, Lordship. In my case, we examined the employer, Lordship can see the evidence, cross-examination of the employer. Nothing adverse has been elicited. Some documents he did not produce. On that, my learned friend has said that because of this, your case is bad. Now, second judgment, Lord, is Mumbai High Court judgment to put forward. The second judgment, Lordship has is Arun Kumar Verma or like some patched up, Milord.
Kamakhya Saha.
Kamakhya Saha. Milord, this judgment is of Guwahati High Court, which basically says that, Milord, page 25, strict rules of evidence, onus sits on them, Milord. Basically, para 25, Lordship. Very small paragraph. Justice A.K. Goswami on that. Lordship has para 25, Milord. The court has stated that in a civil suit, the plaintiff would not be expected to prove his pleaded case beyond any reasonable doubt, but a high degree of probability of the pleaded case would be enough to shift the onus on the defendant. And if the defendant does not succeed in shifting back the onus, the plaintiff burden of proof can safely be deemed to have been discharged. It is also true that so and so the plaintiff can succeed only on the strength of his own case, irrespective of the question as to whether the defendant has proved his case or not. So once we have proved the salary certificate, the appointment letter, they're not disputing the appointment, Milord. In such circumstances, Milord, unless some rebuttal evidence comes up, it was not open for the insurance company to put this into challenge, Milord. This is my humble submission. Now, if your Lordship takes out the salary certificates, Milord, that are there, salary slips are 175 to 193, Milord, of that record, Milord. First, Milord, I will take your Lordship the appointment letter for a moment, Milord. Appointment letter would be, Milord, page 173.
No, that they are not doubting.
No, only thing.
They are doubting the capacity of the society to pay you to the extent of
For that,
2000.
also annex the paper, books of account, Milord, that is also exhibited as evidence, Milord. The books of account of the society. That starts books of account, Lordship, that will be exhibit. Exhibit 13, Milord. Now, once the salary certificate and once a person comes, why he will depose falsely before a court, Milord? He is not my relative. Page 71, the appointment letter, I will just take salary and other benefits, Lordship, may kindly see, Milord, for a moment.
Yes.
Page 71, Lordship, has, Milord.
171.
Only 71, Lordship. Oh, sorry, I'm sorry, paper, my 173, Milord.
Yes.
Second, designation and department office manager. Salary and other benefits. Your salary will be 15,000 per month. In addition thereof, you will be paid a fixed amount of rupees 5,000 per month as expenses for fooding, lodging, traveling, mobile, and other miscellaneous. This 5,000 was deducted, Milord. The tribunal did not consider this 5,000, Milord. That is one of my grounds of challenge, Milord. If your Lordship sees, Milord, now the salary certificate. It starts from page 73. My salary was in the year 2016, your Lordship, 15,000. and it increased to 17,000 from March 2017, which is at page, my lord. Salary certificate starts from page 175, my lord.
How much salary the tribunal took in?
20,000, lord.
20,000.
20,000. My salary was 20,000 plus 5,000 plus 25,000, lord. That was that 5,000 that is miscellaneous expenses, my lord. If you lordship take the salary certificate from March 2017, my lord.
Which salary certificate shows that you got 25,000 in total?
March 2017 onwards. my
Page
lord.
number,
My lord, here, page number 84, my lord, of the
exhibit number?
exhibit number, my lord, 1612. 1612. lordship. Lordship has, my lord. Lordship can take up
But in July, it again came down.
July, my lord, I was absent, my lord. Lordship can see 9 days leave taken. It was deducted.
Okay, so
So my contention is, my lord, this miscellaneous expenses, I am entitled to this miscellaneous expenses, my lord. For that is a settled position of law, my lord. But the Supreme Court also has settled this law. Excuse me.
no, you first counter his case that what has been awarded to you is on higher side. And thereafter you put up your case that you ought to get much more than what has been awarded. So his first objection was PAN 10 and income tax return were not submitted. Second is the deduction towards personal expenses is on the lesser side. It should have been 50%. You address these two first and then
That is post facto change, my lord, of the Supreme Court has settled that law. Sarla Verma, in my opinion, lordship has seen, my lord, it says only deceased, my lord. If it's married and unmarried. Now, the specific judgment, my lord, of petitioner, it is given.
what is your counter to the judgment of the coordinate bench?
My lord, the Supreme Court judgment was prevail, lordship, with all due respect. And if there would have an interpretation, the coordinate bench wanted to have done, my lord, it would have been more wise for him to refer it, my lord, or ask the insurance company to go to the Supreme Court, my lord. My lord, the basically implying something, my lord. Once it is specific, Sarla Verma specifically says, my lord, this is bachelor 50%, married 1/3. So thereafter,
Where?
okay, don't have the, but that is the law that we have read from 2009 onwards.
Show me.
I don't have the copy right now, my lord. But my contention here is post facto change will not imply, my lord. Even if your lordship agrees with the coordinate judgment, but in my humble submission, that will not be a correct law, lordship.
Okay.
Post facto change, para 9, page number 11, my lord. After marriage, this change, after that, you know, when an accident, even any changes will not impact the claimant, right? You know. Lordship has, you know, page 11. Paragraph 9, Lordship.
Yes.
We have thoughtfully considered the rival submission. It cannot be disputed at the time of the day that there in fact were 4 dependents of the deceased and not 3. The subsequent death of the deceased dependent mother ought not to be reason for reduction of motor accident compensation claim, and legal liability crystallize at the time of the accident itself, and change post thereto ought not to be ordinarily affect pending proceedings. Just like how the appellant claimant cannot rely upon subsequent increases in minimum wages, the respondent too cannot seek the benefit of subsequent death of a dependent during the pendency of the legal proceeding. Similarly, any concession in law made in regard by other counsel would not bind the parties as it legally settled that advocate cannot throw away the legal rights or enter into an agreement contrary to law. So very specific, it is not in dispute that I died after the death of my father, the daughter died. So learned tribunal ought to have even awarded me lord the amount of loss of parental consortium lord.
What were the facts of this case which you had relying?
In this case, one of the defendant died. The multiplicand
After filing of the,
after filing.
okay, okay.
Similarly, lordship. Yes, a post accident, any changes will not have any bearing on the.
Okay.
I was not prepared with Sarla Verma today because this judgment squarely covers my case. But my respectful submission before this court would be, Lord, Sarla Verma, when a judgment specifically says something, we cannot.
No, if we go by your submission,
Lordship.
then the question of Sarla Verma does not arise.
not.
If this court agrees with,
That is my submission, but I'm not going on Sarla Verma at this stage.
okay.
This is my submission. Lord. One post facto submission, and it also covers my.
And what is your case for increasing?
One parental consortium, filial consortium to the child will not was to be granted. That was not granted by the tribunal. Second will not that 5,000 rupees allowance will not, that was not granted. Now 30 that was deduction of personal of future interest will not. That is not permissible herein. And 4 million interest 6%. That is on the lower side. No discussion on that will not. These 4 grounds will not.
Yes, any reply?
I can complete or let him reply.
You have completed?
No, I have to support it by reasons, lordship.
Yes, yes.
Sarla Verma comes up, now allowance, that to judgment of the Supreme Court, which says the allowance need to be added,
Regarding that 5,000.
5,000 also. It is equal. That you can take para 12 of Manorma Sinha case, 2025 SSC online 2241 Manorma Sinha, paragraph 20, paragraph 12.
Yes.
Now the next question is whether page
Para?
para 12, page 4, para 12.
Yes.
Now the next question is whether allowance are to be added in the salary for determining the multiplicand. In National Insurance Company so and so, it was held that the term income has different connotation for different purposes. A court of law having regard to the change in societal consider the question not only having regard to pay packet of the employee carries home at the end of the month, but also other perks which are beneficial to the members of the entire family. In so-and-so state, so-and-so, a three-judge bench of this court noticing earlier decision on this point observed that incomes should include those benefits either in terms of money or otherwise, which are taken into consideration for the purpose of payment of income tax or taken into consideration for the purpose of or professional tax, or although the element thereof may not be taxable due to exemption conferred thereupon under the statute. Following decision so-and-so, so-and-so, so-and-so. It was held by this court that annulments and the benefit accruing to the deceased under various heads for the purpose of computation of the loss of income ought to be included irrespective of whether they are taxable or not. That in our view, the High Court erred in excluding the allowances from the computation to arrive at the multiplicand.
In your case, on what basis 20,000 was taken as an income?
Salary, only salary.
No, which salary? Last salary?
Last salary.
What was your last salary?
Last salary 20,000.
Total emoluments were 20 plus. Okay,
25.
okay.
The second judgment also, paragraph page 2, para 5 and 7. as Lordship has seen, my lord, private companies, my lord, they get all the extra benefit. They are provided with car. So when you join a service, my lord, we see all these factors that HRA is provided, house car is provided, driver is provided. All this has to be added, my lord, because when we go for an interview, my lord, then they told me, they tell us that we are providing you this much, this much, this much, and this much of salary. So everything need to be calculated. Otherwise, all private job employees, my lord, will suffer loss, my lord, if such things are being curtailed, my lord. Page 2, my lord, paragraph 5 and 7. Lordship has, my lord.
Yes.
Against the judgment and order passed by the tribunal, the insurance company filed appeal before the High Court, which, as notice above, was partly allowed for assessing the monthly income of the High Court took into account only the monthly salary of the deceased and excluded the amount of daily allowance of rupees 50 from consideration, observing as follows. However, the tribunal erred in including bhatta of rupees 50 per day as a part of the salary and assess the monthly income of the deceased. Bhatta is not paid as a part of the salary, but is paid whenever there is work. It is well settled that bhatta shall be calculated in the salary assessing income of the deceased. So, Section 6 we can ignore. 7. We are unable to appreciate the view taken by the High Court on both counts. First, there was no evidence that the daily allowance was not paid to the deceased every day, or even that he was not at work on every day of the month. On the contrary, there is evidence on record that apart from the monthly salary of 25, he was getting rupees 50 a daily allowance, which therefore hold, my lord. Here also, if your lordship says, every month I was entitled, if I take leave, I was entitled to 5,000. I don't take leave, I am entitled to 5,000. Just because the nomenclature is something, my lord, that amount could not be deducted from my, should have to be included, my lord.
Okay.
The third judgment is of Delhi High Court, my lord.
So on same point,
Same point, lord.
same point, two judgments are enough.
Lordship. So this 5,000 need to be included, my lord. Now, what is future prospect, my lord? The first concept of, I prepared one written argument but could not bring it, my lord. The first concept of, my lord, future prospect is, my lord, it should be from to a future date. Now, future prospect, while calculating future prospect, lordship would see that, my lord, 10 years. Well, if highest is 18, my lord. 20 to 25, the highest. The highest multiplication in 18, my lord. And the future prospect calculation, my lord, if your lordship sees, my lord, is 40% and 25%. 40, I come within the age group of 40 to 50, 10 years of future prospect, my lord.
How much the tribunal took into consideration the future prospect in your case?
Lordship can see the judgment, my lord, of my appeal. Page number 20 of my appeal. Two aspects, lordship, I will take the lordship to a judgment, my lord. One is no discussion what should be the rate of interest. Arbitrarily says 6%, my lord. Second, this future prospect, my lord. No discussion says without this, my lord, this has to come to this. But this is law, there is law, my lord, which supports the factum that future prospect, interest on future prospect need to be deducted, my lord. That is also there, my lord. Now, lordship can see the last paragraph, my lord, in the order. In the result, the claim petition is allowed, awarding rupees so and so. So only opposite party number 3, Reliance General Insurance Company, to pay the compensation within 30 days of the receipt of the order. The awarded amount excluding future prospect 6,000 into 12 into 3 equal to 6,24,000 will carry 6% interest per annum from the date of the so and so, my lord, till so and so. So 6,24,000, lordship. From this, no interest was granted. So my contention, my lord, is that I was in the age group of 40 to 50 years, my lord.
Yes.
Now, any amount granted is for 10 years, my lord. Now, the case was of 2017 till 23, we are contesting the case. Where is the question of getting future prospect, my lord? They're still having my money, they're still earning interest on that. And they're denying me on the, these are all fancy words, my lord. Sounds very sweet to the ears.
No, no, what is your submission?
My
What?
submission is this, my lord, that 10 years have passed, almost passed. This income, it has not remained future. The concept on which the future prospect, the interest on future prospect is denied. The concept is, my lord, that this is a future income. You will not get it today. On that concept is the judgment of 1995 Supreme Court, my lord, that I don't have the copy right now. In that it stated, my lord, that because some medical expenses, my lord, suppose for treatment, some amount was to be given to the claimant, 1 lakh was given for future medical expenses, my lord. On that, interest was to be deducted because that is for future medical expenses. Already the medical expenses with the claimant is submitted before the tribunal. Now, the insurance company, what they did, they brought that concept here and said all incomes when future concepts not carry interest, my lord. That is not the correct position of law. Two 2017 accident, 2026, the income has not remained as future, my lord. So interest cannot be denied. 2 views possible, lordship should take a view favors the claimant, my lord.
No, the judgment does not say that. It does not speak anything about future prospects.
Lordship, rupees so and so awarded to pay company 30 days, received the awarded amount excluding future prospect.
Yes.
Rupees, my future prospect was so and so. So future prospect will not carry any interest, my lord.
Where is the future prospect?
Lordship, if first, second, third, fourth, fifth line, if your lordship takes up.
Yes.
The awarded amount, lordship has, my lord.
Yes.
The awarded amount excluding future prospect.
So nothing was awarded against future prospect.
No,
It does not speak about interest
it-
on future prospect.
Yes, it says that, no, nothing has been spoken about. In the judgment, there is nothing. Simply this has come up. So. And my submission is after judgment is of 2023, 7 years of the accident, my lord. Where does it, how does it remain future, my lord? The insurance company with my understanding of MSCT laws, my lord, is that taught, my lord, that they use fancy words to attract, my lord, it create attraction, laws are being
No,
passed, my
you
lord.
be clear.
Lordship.
Oh, as regards the operative part of the judgment, what is your submission?
The deduction toward future prospect, my lord. The deduction of interest toward future.
It does not indicate that any interest has been deducted.
It excluded, my lord. That part has been excluded. Interest part has been. The awarded amount excluding future prospect, so and so will carry.
No, excluding future prospect
Will
means
carry 6%.
what it means. It means that nothing was awarded against future prospect.
No, they have awarded, no, that is there.
It does not say that interest on future prospect.
Annual income has been considered 26,000.
Where is the computation of the annual income?
Page 19. Page 19, paragraph 22 onwards, my lord. Annual income already is 26,000 into so and so, it comes to after deduction so and so, it comes to this, and multiplying with applicable amount will come to this, my lord. So if we add 30%, my lord, then it will come to 30,000, 30% of 20,000 given. 30,000. 30% of
So 30% was added towards,
30% of what? The future prospect.
towards future prospect.
And if you also see 30% of 20,000 million into 13, it will come to 6,24,000 million.
Okay.
That is the second one. Future prospects should not have been deducted because this is not remain future million. Now we are in 2026 million. Lots will pass an award. Thereafter, the insurance company will deposit it. It will again be June, July. Most probably the date will come out of that million. Now, second is the interest of 6% million. Now, the insurance company million always argues on the point million that bank grant interest of 6% million. One of the submission of the insurance company that I find me lost in the matter. There are many judgments we will take a lot to. One in Niru judgment is not submission to judgment. Let's say this is bank grant compound interest below. And it has to be compounded. I have the bank clause below every 7 days, 15 days or 7 days below. It specifically says the Reserve Bank guideline is there. So there the cool place lies now. They say that they are granting interest as per the bank's rate. Bank is granting compound interest. They are granting simple interest. Lots of can calculate the difference. In all fixed deposit, bank grants compound interest. And Lotsif has heard on the interest point at different times. This is always the submissions of the bank that they, the insurance company, that bank are granting interest at this rate.
Okay.
Now, this is the price difference calculation, Lordship. One Lordship can see. If I would have got money in 2017, what difference it would have made me, Lordship? It is from the gold to potato and tomato. All prices have been reflected from online. The difference, minimum difference is coming is 317% to 6,709%. So 2000, the value of money at that point of time, I would have gotten Milord. And the value of money today, that calculation cannot be the same, Milord. And in such circumstance, what happens? The insurance company always wants to prefer appeal. Reason is very simple. The more they can retain our money, Milord, retain our money, it is beneficial for them. They're not losing on the part of interest. They're earning much more than 12-15%. So why not retain the money? Delay the amount to the claimant so far as possible. And what's happened? The claimant runs from pillar to post.
So how much interest you should have got?
Well, at least 12% in terms of the workman company.
Where is that prayer in your memo of appeal?
18% I am praying for.
Where?
The memo of appeal.
On what basis?
Let's say one, that the delay part that has been called, if you Lordship take the order sheet, Lordship can see there one judgment. I will just one judgment on insurance, where this custom has been brought by the Supreme Court that if the insurance company would have given us the amount on the day of the accident, the liability of insurance would not have been there. Let him finish, we'll take this judgment, we'll place it. Only one judgment on that point, Lord. And the price difference that I have placed before you, Lordship, Lord.
Yes, Mr. Sakya, any reply?
So, my learned pen has submitted citations where it says that in MSCT cases, burden of proof is less. That is true, but that does not mean that the statutory provision that will have to be discarded. So, the filing of income tax return, and in their claim petition also, they have stated they had filed they have paid income tax return. Then they have filed income tax, but there are no document to prove that they had filed income tax return. And having PAN and income tax return of the LS NGO, that is also statutory requirement, Lordship. So without any statutory requirement being fulfilled by the LS NGO, how can Lordship can assume the salary given by that NGO to be a genuine one or true? That is the Lordship one thing. Next, Lordship, my learned friend has stated that no amounts would have been deducted for amount given in the head of loss of future prospect. No interest is awarded by the learned tribunal, but in their appeal there is no such ground, Lordship. In their appeal they have not taken any ground that amount given in the head of future prospects should have carried interest. There are no ground, Lordship.
Okay.
And my learned friend has submitted that the daughter who has expired during the pendency of the case should be also given parental consent amount, Lordship. Lordship, when a person is no longer alive,
No,
Huh?
that
Lordship,
concern.
Lordship,
Regarding daughter, his submission is that the deduction of 50% or 1/3 deduction, if daughter has died after during the pendency of the proceeding, then the deduction is not warranted. He cited some judgment in support of his case. Regarding loss of consortium, whether wife was given loss of consortium,
yes, Lordship.
you are claiming for daughter, deceased daughter. Okay.
Lordship, in this case, now I have seen the trial court record where it is written in death certificate that daughter was married. Her husband's name is mentioned, but in the claim petition they have not stated that she was married daughter.
At the time of filing, she was not married.
There was
Because
no
the
divorce
FIR
one
also
also.
belonged.
So if she was married, that should have been in the evidence, Lordship. If she was already married, so her dependency on her deceased father was not there, Lordship. But that was not in the record, Lordship. They have not disclosed anything regarding that. Only death certificate shows that her husband was some Vishal Bhuya.
Okay, that's better. Huh? Okay. Heard.
That's one judgment was also accepted, Supreme Court judgment, my lord. It is with regard to the future prospect as well as the interest part, my lord. We have given a copy. Oriental Insurance Company. will
Mr.
give you
Tiwari, your matter we will be taking at 2. At 2 you, instead of waiting for 15 more minutes, we'll take it up at 2. Yes, what is judgment?
my lord, this, paragraph 11, it is with regard to the future prospect, my lord, and why the insurance companies are, my lord. Page 4, my lord, paragraph 11.
Yes.
In fact, it is due to the repudiation of the refusal or to consider the claim of the claimant are driven to the tribunal. When the matter is pending before the tribunal or in appeal before the higher form, the claimant are deprived of the compensation for future prospect. If they are paid in time, it could be utilized by the claimant on the failure. The loss of dependency would force the claimant to source their livelihood from elsewhere. This is sought to be compensated at least minimally by award of interest, which oftener than ever is nominal, and also since only simple interest is awarded. If the amount were disbursed to the claimant on a rough calculation on intimation of the accident to the insurance, that should be the law, my lord. On the intimation of the accident is not disputed, my lord. Everything will come into place.
No, but why I was putting query to you regarding future prospect.
That was denied to me, my lord.
No. In last paragraph says that awarded amount excluding future prospect.
Yes, should carry interest.
Now, so the awarded amount is 6 lakhs
No,
24,000.
Future prospect is 6 lakh, whatever amount is 27 lakhs, my lord.
Oh,
And the future prospect is 6 lakhs 24,000.
okay, on 6 lakhs 24, you will not carry.
I will not carry interest, my lord.
And this judgment para 11, what it says?
Well, it basically says that if the insurance company would have given us, well, at the time of the accident, or when the claim petition was filed, or when the appeal was pending, my lord, in such circumstances, there would not have been any liability of interest.
Lordship, only after adjudication of the matter, Lordship, it can be decided how much they are entitled. So at the initial stage, it is difficult to pay.
And they
But
also
in this case,
difficult to pay interest also,
we
my
have
lord.
also, Lordship, paid the 50% amount along with interest, Lordship. Out of 27 lakhs, we have already paid 17 lakhs something, Lordship.
Okay.
The 50% along with
This
interest, they have
judgment
already.
says about the
received,
future, my submission for future perspective to that extent, my lord, that it has not remained future. So again, denying me interest on that, my lord, would further harm me.
We heard Mr. A.J. Sakya, learned counsel for the appellant in MAC appeal number 458/2023, as well as respondent number 3 in MAC appeal number 422/2023. Also heard Mr. A. Lal, learned counsel for the respondent claimant in MAC appeal number 458/2023, and the appellant in MAC appeal number 422/2023. By this common judgment, this court proposes to dispose of the MAC appeal number 458/2023, as well as MAC appeal number 422/2023, since both the appeal arose out of a common judgment and award. The common judgment and award dated 14/9/2023, passed by the Motor Accident Claims Tribunal number 1, Kamrup Metro, Guwahati, in MAC case number 381/2018. Stop. The insurance company has filed the MAC appeal number 458/2023, challenging the quantum of the compensation which was granted to the claimant respondent side. The contention of the insurance company is that the compensation awarded to the claimant is on higher side. On the other hand, the MAC appeal number 422/2023 has been filed by the claimant respondent, by the claimant praying for enhancement of the compensation awarded to her, contending that the compensation awarded to her is on the lower side. Stop. The facts relevant for consideration of both the appeals in brief are that the appellant in MAC appeal number 458/2023, namely Srimati Rita Bora, who is also the claimant of the Srimati Rita Bora has preferred a claim petition under section 166 of MV Act 1988, seeking compensation on account of death of her husband, the late Sarath Bora, in a motor vehicular accident on 9/8/2020.
Date of accident is 10/10/2017, Milord.
Stop. The accident in which accident due to which the vehicular accident due to which the husband of the claimant expired occurred on 10/10/2017 at about 6:15 p.m. near Dimo Charali on National Highway number 37, Nagaon. Stop. The husband was driving a motorcycle.
No, pedestrian. Milord.
Pedestrian.
One motorcycle came and hit me.
It is stated in the claim petition that on the date of accident, the husband of the claimant was knocked by a motorcycle bearing registration number AS21F4601, which was driven in a rash and negligent manner at the time when the accident occurred. Stop. The claim petition filed by the claimant, on the basis of claim petition filed by the claimant, MAC case number 381/2018 was registered, and the insurance company contested the claim by filing written objection. Stop. Ultimately, by the impugned judgment and award, an amount of rupees 27,81,000 was awarded to the claimant with a interest at the rate of 6% per annum, excluding the interest on future prospect from the date of filing of the claim petition till the date of realization. Stop. Learned counsel for the insurance company in his insurance company has contended that while assessing the annual income of the deceased, the concerned tribunal failed to take into consideration that the deceased was shown to be an employee of a NGO, namely what is the name? Namely Prakritik Aru Sishu Kalyan Samiti. However, he submits that though the tribunal accepted the salary certificate as well as appointment letter exhibited by the salary slips as well as appointment letter exhibited by the claimant during the claim proceeding, the tribunal failed to take into consideration that the claimant failed to produce any PAN number, TAN number, or income tax return to show the veracity of the earnings of the, to show that the, to show the earnings of the said NGO and its capacity to pay the salary shown to have been paid to the claimant. Remaining in jail. I'm reserving it. Not so and so, both the cases. Hearing concluded, judgment reserved. Yes, Mr. Alam, anything?
Also, I just want to say one thing, Latif. Our interest, statute deposit may be returned, Latif, along with interest. No? It is our one prayer. So one decision is there. So I'm submitting this decision.
Yes.
Item 21 was there. Both of us unfortunately could not appear before your lordship at that point of time.
It is an order for early hearing, your lordship.
What was the order passed?
To fix on 4th of.
For fixing, fixing today for hearing, final hearing.
When we have fixed, we have already passed order. We have two matters to be heard. Now, what is your prayer?
This may be taken on 17th February.
17th February. Okay. Item number?
21.
Item number 21. Reflect the name of counsel. M. Devi was there.
Yes.
You were not there.
Both, she was there.
She was
on
there.
my behalf.
She was there.
My junior was there.
He was also.
She was not there. She might be sitting.
She might be behind her.
No,
not
no.
Not this side.
She was not
This
aware
side.
of that.
okay. Show the name of the council. List the matter on
17th February.
17th of February.
Yes.
In the hearing list.
In the
hearing column.
Hearing
In
column.
hearing column.
Much.
So which one should we take?
The choice of the rest.
We'll take lesser time. We'll,
14,
how much?
33 minutes.
Already lordship heard it.
Okay, we'll hear your matter also. Let us take the insurance matter first.
Item 14.
This is part heard.
Yes, sir.
Part heard. Lordship, actually, the main moot question here, what we have challenged is that the court not accepting that the pay and recovery issue, Lordship, because in this case, we adduced evidence to the extent that the vehicle was taken on hire because of the document exhibited by the claimant herself, Lordship, the charge sheet.
No, what is your ground?
Mine, yes.
Otherwise, accident is not, you are not
No, no.
contesting.
It's not content. Accident happened, but when the vehicle was taken on hire, and that has come out in the charge sheet, which was exhibited by the claimant. The court did not accept the evidence, Lordship, because it said that it was beyond pleading. But I have annexed the written statement, Lordship, at paragraph 12, we have taken the plea. Violation of policy condition. And
Where is the observation of the court?
Lordship, paragraph 19.
Page number?
Page number 11 of my memo of appeal. Or internal page 6 of the judgment. Lord.
Yes.
Now, in view of the above discussion and observation, it is concluded that the plea of the insurance company that the offending vehicle was used in commercial purpose is beyond pleading and the same has not been established. So it is held that OP party number 3, the Oriental Insurance Company, is liable to pay the compensation. But it is not beyond pleading, Lordship. That day also I showed paragraph 12. That is page 16 of my memo of 15 of my memo of appeal, Lordship. The written statement, it starts from page 14.
Yes.
Paragraph 12. That with regard to statement made in paragraph 14 to 17 being matter of record, however, the answering opposite OP insurance company denied the same. In this connection, OP number 3 states that the liability, if any, will be subject to the fulfillment of all necessary conditions provided under the MB Act, so and so. The OP number 3 is not liable to
What condition was violated?
it was taken on hire. Lordship, I have also annexed the insurance policy, Lordship. At page 18. There are many issues, Lordship, like DL, permit, hire. Limitations as to use, Lordship. After the vehicle number are returned.
What it says?
The policy covers use of the vehicle for any purpose other than a hire or reward. We are on this, Lordship. And Lordship, that day I was arguing about pay and recovery, and in fact, the claimant, the respondent claimant advocate also submitted the judgment of pay and recovery. Lordship, it is there in the yes.
Owner is appearing.
No, notice served to the owner, but owner and driver is not before the court too. I am for the claimant. And my learned friend is also for another.
I am the unmarried sister of the deceased. I am the respondent number 4.
Okay.
And Lordship, if pay and recovery is there, that also I submitted these judgments last time, Lordship.
Now, what the tribunal directed?
No, it did not give any pay and recovery right.
Okay, you are pressing for that.
Yes, I'm pressing for that.
That you will pay and you will recover.
And they have also, they have strengthened my case only. They have also submitted that judgment. I have submitted different judgment. They have submitted as Ayyappan Lordship versus United, that is pay and recovery.
We have no any objection, my lord. If they pay the compensation amount to us and they have to proceed for recovery before the trial.
I'm submitting these judgments, Lordship.
I have
One by one.
But whether notice to owner has been duly served in this case?
Lordship, the pay and recovery will be done by the tribunal as per the.
No, but.
Oh, yes, it is
But,
duly served.
sir.
It is served, Lordship. He knows intentionally he did not appear, Lordship. Lordship, office note dated 3/6/23. Process server received and signed by his wife, Pompey Das. Flag service report, list for hearing in November.
The owner is respondent number?
2. Office note 3/6/23 and ordered Lordship is of 22/9/2023. Court's order
22/9.
23.
How much was the compensation?
Compensation amount was.
19 lakhs 58,000 and 6% interest.
Twenty-two nine does not indicate properly. It says both parties are represented.
But the office note dated 3/6/23, Lordship. Office note, his wife received the notice, Lordship, from P. Das. And it is flag service report is there, Lordship. Flag mark is service report. Because, Lordship, from the tribunal, again a notice will go to him.
No, but once we hold that he has to pay, he cannot challenge that before the tribunal.
No. It was open for him to come and challenge here itself.
If your lordship peruse the cause list, today's cause list, lordship, counsel representing the respondent number 2, VP Bora, PJ Dutta, their names are reflecting here. No, we are respondent number 1, respondent number 2.
Yes.
Respondent number 2 is there, lordship, advocate.
Represented.
Yes,
Yes.
yes.
Wakalatnama asene.
Yes, sir.
Hmm.
PB
Check
Bora
karo.
and PJ Dutt.
BP Bora, PJ Dutta.
They are not of our group.
They are for respondent number 2. We are representing respondent number 1 and he is 4.
Wakalatnama sauksu. Because we have to first hold that the appeal will proceed ex parte against him.
Yes, lord.
It has not been held earlier by this court.
Oh,
There has to be an order.
but since the council is there, Lordship, will it be ex parte?
Council is not present today.
Yeah,
They are never present. I have never seen him.
I've never seen them.
And actually, I thought he is the.
That will be reflected so that in future, if the owner must have must know what happened in the court on that day.
The best thing for him to know is that his counsel did not appear.
Yes,
His-
because he has engaged a counsel. If he,
engaged a counsel. Two.
what is the name of the owner?
Name of the owner is Shiba Das.
Ritul Das, RITUL, Ritul Das.
Wakalatnama asene. Heard Miss R.D. Majumdar, learned counsel for the appellant. And this is item number kiman asine?
14.
1-4.
14. Miss R.D. Majumdar, learned counsel for the appellant. Also heard Mr. P.P. Bhattakur, learned counsel for
Number 1.
respondent number 1, as well as Mr. R. Deka, appearing for respondent number 4. Diok. ভালকে চাওক। None has appeared for the respondent number 2. Though
3 also. Lord.
3 also, 2 and 3.
2 and 3. Who is 3?
Driver.
Driver of the offending victim.
None has appeared for respondent number 2 and 3. though on perusal of the office note dated 3/6/2023, it appears that notice issued to respondent number 2 through usual mode was received by the wife of the respondent number 2. It also appears that on perusal of the cause list that names of 3 councils, namely Mr. B.P. Bora, Mr. P.J. Datta, and Mr. R.S. Ranghan, are shown in the cause list as engaged counsel for respondent number 2. Stop. Wakalatnama. I will verify that.
It's better to.
Learned counsel for the appellant submits that this appeal is mainly preferred by the insurance company on the ground that there was a violation of the policy condition by the owner within bracket insured. However, the tribunal ignored that fact and rejected the plea of the insurance company that it is not liable to indemnify the owner in respect of damages paid to be paid to the claimant. She submits that the insurance policy clearly stipulates that the insurance company is liable only if the vehicle is used for any purpose other than the purposes mentioned therein. One of the prohibited purpose is to use the vehicle for hire or reward. ইয়াত থাকিব নিশ্চয় ভালকে চাবচোন
ওলাইছে
Computer loss.
wakalat number.
It therefore submits that even if insurance company is directed to pay the compensation to the claimant, it may be allowed to recover the same from the owner. Stop. The claimant, learned counsel for the claimant, namely Mr. P.P. Bhattakur as well as Mr. R. Deka, did not contest, did not oppose the submission of learned counsel for the insurance company. Pale, wakalatnama. I will verify. If I find it, the appeal will be shown as heard ex parte against both the respondents. And
But
it will,
since it is in the computer lordship, maybe at times what happens, wakalatnama gets displaced or something. But if once entry in the computer is there, that means they have filed because that is the first, the wakalatnama comes to section later on. First in the filing section, the entry is made. At times we file wakalatnama and the case comes up, it is not in the record, but our names are shown in it.
though hearing is concluded, however, no, on the basis of office report as well as cause list, wherein the name of the counsel for respondent number 2 has been reflected, it appears that the respondent number 2 within bracket owner has made his appearance. However, when the matter was called on for hearing, no one was present to represent respondent number 2. Therefore, this court decided to proceed ex parte against respondent number 2. The court master is, however, directed to verify from the record as to whether wakalatnama filed by respondent number 2 is there in the records or not. After getting his report, he will submit his report on 27th of January. List this matter again on 27th January. On that day, I will decide what is to be done.
These judgments were kept that day I can give or? These are not the cause, but
This matter shall proceed ex parte against respondent number 2. It will continue. After getting report, I will decide.
Lordship at 2 p.m.
Okay, at 2 p.m.
it
Bec-
could be
bec-
your-
because
only
he-
judgment I'm submitting, Lordship,
Yes.
it's not burdening with the, yes, paragraph 8.
Learned counsel for the appellant has Learned counsel for the appellant has also cited a ruling of the apex court in the case of Oriental Insurance Company Limited versus Sri Nanjappan and others reported in 2004 13 SCC 224. Let the same be tagged with the case record.
Lordship, I have 4 judgments. If your Lordship allow me, then I'll place it today, otherwise on 27th.
On 27.
Okay.
27 we'll decide
Lordship.
whether to proceed. Otherwise, materials are there to proceed ex parte, but let them verify.
Yes, Lordship.
I'll oblige.
May I please, your Lordship? My lord, the matter is with regard to tenancy under the Assam Urban Area Rent Control Act 1972. My lord, before I should take your lordship to the judgment passed by the First Appellate Court, my lord, I would like to narrate a little happened in between the landlord and tenant.
You are tenant.
I am tenant. My lord. I'm tenant.
Yes.
My lord, prior to the filing of title suit number 185 of 2013 by my landlord against me, I had filed a title suit against him, against my landlord, and that was numbered as TS number 462 of 2012, along with an injunction application, my lord.
Yes.
The prayer in that was, my lord, I have already annexed also, my lord, I will take your lordship to that. The prayer in that was that my landlord has closed the drain and the outlet. That's why I am facing some problem in my godown while going to. Now, as against that, my landlord filed the written statement. And in that written statement, my lord, in the year 2012, there was no mention that the premises is bona fide required by my landlord. Because my lord, at that time, my landlord was having an amount of rupees 1,25,000 as advance to be adjusted at the rate of 1,000 per month against the rent of every month. So that was a suit prior to the filing a suit for eviction against me only on one ground, that is the bona fide requirement. Now, my lord, it may be out of jealousy that when that my suit was decreed, 462, 2012 was decreed, he never filed any appeal, but he filed title suit number 185 of 2013 on 17/5/2013.
Okay.
So it may be, my lord, and
When it was decreed?
Uh,
Your suit,
It was decreed, my lord.
when?
Yes, it was, my lord, on 29/8/2015, my lord.
In the year 2015,
Yes,
after filing of this.
after filing of the title suit for eviction.
Okay.
Eviction. So that's why I am submitting before your lordship that it may be out of grudge, out of jealousy, or out of frenziness that my landlord, before the disposal of that suit, had filed title suit number 185 of 2013, finding no any other ground, because I was not defaulter, finding no any other ground than to say for bona fide requirement. Now, my lord, so far the premises is concerned, premises is a godown. My business establishment is since time immemorial, because my father was having a trade in the name of Assam Trade Agency, my father. His father was also having the business at SRCB Road. So nearby, when this premises was vacant, he approached me, I mean my father, to let out that for the purpose of godown. And at that time, the rent was, my lord, 3,500 rupees only. So the first tenancy agreement with my father and the present landlord, my lord, was in the year 2002, for a period of 5 years.
Okay.
And the rent was fixed to the tune of rupees 3,500, my lord, and 1,25,000, which my father had paid to him, that was stipulated to be adjusted at the rate of 1,000. So I was to pay only rupees 2,500. My father was to pay only rupees 2,500 till the year 2007. After the expiry of my father, I entered into an agreement with the same landlord in the year 2007, and there the stipulation was that it will continue up to the year 2012. Up to the year 2012. Now, my lord, in the year 2012, as I filed the suit, that is suit number 462 of 2012, this gave him a clue to file a suit against me in the year 2013 for my eviction. He could not have taken any other ground, reason being my advance was lying over there, and I am yet to get, my lord, rupees 5,000. That is as per the lower court judgment, which was required to be refunded. I will take your lordship to that part. Thereafter, my lord, the suit was contested. Thereafter, my lord, various letters were exchanged in between, and in none of those letters, my lord, my landlord have ever referred that he needs the premises bona fide for his business or for any other purpose. Business cannot be conducted because the premises is used as godown, no any other infrastructure other than that of one door to keep the goods in and to take it out, my lord. Now, the judgment was passed, my lord, in this case on 25/11/2016
By the trial court.
by the trial court. It was decreed. May I take your lordship to that judgment?
Yes.
Or,
What page number?
yeah, my lord, that trial court judgment is at page number 29. This is, my lord, 27, 33 to 52.
What the trial court held?
Yes. My lord, that observation your lordship will be pleased to see at page number 47. Page number 47. And issue number 5, I would take your lordship to issue number 5. What are the reliefs the parties are entitled to? The plaintiff is entitled to the decree or reliefs as paid in the plaint, as well as the cost of the suit from the defendant. My lord, when the landlord has filed the case for eviction of mine, it was totally absurd to impose any cost upon me. So the plaintiff is entitled to the decree or relief as prayed in the plaint, as well as the cost of the suit from the defendant. However, the plaintiff in the plaint as well as during argument admits that remaining advance amount deposited by the defendant at the time of commencement of tenancy, that is rupees 5,000, is in the hands of the plaintiff and he is ready to return the same to the defendant. Therefore, the defendant is entitled to return back rupees 5,000 from the plaintiff. My lord, clear stipulation was that because for what necessity he has taken rupees 1,25,000 as advance as against the rent of rupees 3,500 only. The learned trial court has come to the finding that whatever the advance is lying in the hands of the plaintiff is to be returned and I am entitled to get it back.
Yes.
So there was no question of defaultership. This, issue number 5 itself entails. Thereafter, the order part, my lord. In view of the discussions made above and the decisions reached therein, the suit of the plaintiff is decreed on contest with cost. The defendant is liable to be evicted from the suit premises. The defendant shall pay the cost of the suit to the plaintiff. The defendant is entitled to get back the remaining advance amount of rupees 5,000 from the plaintiff. The plaintiff is directed to return rupees such and such to the defendant. Prepare decree accordingly, giving under my hand and seal of the so and so. My lord.
No, what
This is the-
reasoning, was the finding of the trial court on the issue of bona fide requirement?
Yeah, my lord, the issues are reflected at page number 39 and 92, my lord. Page number 39. Issue number 3 is most important. The bona fide requirement, which is answered, my lord, at page number 42.
42, yes.
42. My lord.
What was held?
Yes, my lord, the plaintiff's main contention in this present suit is that he is an educated, unemployed youth, having his wife and a minor child, and as such, that expenditure to maintain his family is increasing day by day, and he has no other source of income to maintain his family members, so he decided to run business in the said suit premises. The plaintiff has no other accommodation for running a business to earn livelihood. Suit premises is required for bona fide of the plaintiff, which is alleged to be unauthorized occupation of the defendant tenant. In the evidence of PW1, Sajauddin Ahmad, during his evidence deposed that the suit premises is required for bona fide purpose, and therefore on enquiry of the tenanted premises, notices are issued to the defendant to vacate the suit premises. Legal notice to the defendant dated 30/9/2012 is marked as Exhibit 5, asking the defendant to vacate the suit premises within 7 days from the date of receiving the legal notice. The defendant's witness have admitted that they have received the notice for vacating the suit premises and marked the same as Exhibit F. The defendant witness number 1 and 2, Yashpal Chachra and Kamal Lal Chachra, have admitted during cross-examination that tenancy is expired and on expiry of the tenancy it is renewable at the option of the landlord. Thus, the defendants have admitted that plaintiff has the option either to renew the tenancy, to declare the tenancy as expired. The tenancy agreement is marked as Exhibit number 3, showing the commencement of tenancy with the defendant on 1st September 2012, which expired on 31/9/2012. Both the parties have admitted the execution of Exhibit number 3 and the earlier tenancy agreements marked as Exhibit number 2. The same documents are also exhibited by the defendant by Exhibit number A and B. From the admission of the DWs, namely Yashpal Chachra and Kamal Lal Chachra, and it appears that the tenancy is expired and the plaintiff, being the landlord, has absolute authority to declare the expiration of such tenancy. Here, in this present suit, the plaintiff has asked the defendant to vacate the suit premises only on the ground of bona fide requirement or for his own use. During argument, the learned counsel of the defendant has stated that bona fide purpose of the plaintiff is not honest and genuine. The defendant has referred the laid down law in G.C. Kapoor versus Nand Kumar Bhashin and others, 2002, 1 SCC page 610. In this above referred case, the Honorable Apex Court held that the bona fide requirement of landlord should be honest and not tainted with any oblique motive and should not mere desire or wish. In the present suit in hand, though the defendant has argued that the bona fide requirement of the plaintiff, landlord oblique plaintiff, for establish his own business in the suit premises for accommodation of his family is dishonest and concocted. However, at the time adducing evidence, the defendant failed to discharge his burden to prove the dishonest requirement of the plaintiff. The DW1 and 2 have not adduced any supportive evidence to establish the dishonest requirement of the plaintiff. My lord, here, before I should proceed further before your lordship, I would like to submit here one thing, that if he is not having any other premises for his business, and if he is not having any other income other than that of rupees 3,500, this is continuing since the year 2002. Since the year 2002. So if a person with the same family can survive out of rupees 3,500, that too 2,500 after adjustment of 1,000, if he can survive, then why he cannot survive after raising the amount from 3,500 to 5,000? Because the amount of rent was raised on 1/10/2007, my lord, to the tune of rupees 5,000. Here the period from 2002 up to the year 2007, my lord, he was surviving only from rupees 2,500 because 1,000 was getting adjusted. Now that was enhanced to rupees 5,000 on 1/10/2007. 1/10/2007 to the tune of rupees 5,000, double the amount, my lord, double the amount. So this observation of the learned trial court is not upon the basis of fact finding, rather it is on the basis of presumption. Now I am taking further, my lord. As per defendant's contentions, at the age of 40, the plaintiff cannot be considered as a youth and there is no scope for starting a new business in the suit premises. In this regard, the bona fide requirement of the suit premises by the plaintiff, the Honorable Supreme Court of India in Raghavendra Kumar versus Firm Frame Machinery and Co. AIR 2000, Supreme Court 534. It is held that as per the settled position of law, that the landlord is the best judge of his requirement for residential and business purpose, and he has got complete freedom in the matter. In this present case, also the plaintiff is the best judge of their requirement, as they have stated that suit premises is required for their own use and for starting a business. I am not on that, my lord. I am not on the ratio what was given by the Supreme Court. Supreme Court in this case, my lord, perhaps has come that a landlord is having more than 2 or 3 premises. Out of that, he can choose any one for the purpose of bona fide requirement. But here, my lord, this is the only premises as per the findings and as per the evidence. That is the only premises, and he at the age of say 35, here the age is written as 40, my lord, in the year 2016. Say at the age of 35, he let out the premises, whether at that time he was not in the mood of business or opening any business, so that he let out the premises to me. So in that way, my lord, here the Supreme Court has observed that if a landlord is having more than 1 or 2 premises, then he is the best judge to choose from which premises his bona fide requirement can be fulfilled. But here is not the case. This is the only premises. So in this way, this judgment, though is cited, but not applicable. Hence, in this present suit in hand, plaintiff, I'm reading, my lord, page number 13, internal page 13 of 20.
Yes.
Here in this present suit in hand, plaintiff considered himself as unemployed youth and willing to start his business in the shoot premises. Being a landlord, he is the best judge for his requirement of the premises, which let out to the defendant as tenant. If a person is desirous to start his business in his own premises, the age of the person cannot be considered as bar in this context. Therefore, the law laid down in the said judgment is best applicable here in this present suit in hand. My lord, though out of court, but I would like to submit here that all the players get retired at the age of 39.
But my
Why-
learned senior counsel at the age of 75 is arguing a strong man.
Yes, because this is a profession. But that is a profession where the players are getting retired at the age of 40. Why, my lord? Because their age is not that which can put that efficiency like Tendulkar at the age of 18. That's why they are getting retired.
And thereafter,
My
only, my
learned-
lord, thereafter they are doing businesses, my lord. After 45, they are Dhoni.
Yes,
Tendulkar,
business is something different.
This is what I'm asking.
Business is something different. But if a person can pull on up to the age of 40 years on the rental income, my lord, on the rental income, after that, his choice to have the bona fide requirement or to have the premises required for bona fide purpose and that too for his business, that potentiality he has lost. And the players are losing the potentiality at the age of 40. That's why they are retiring. That's why they are retiring. My lord, thereafter, moreover, there is a further I mean this. Moreover, in Dinesh Kumar versus Yusuf Ali, 2010-12 Supreme Court cases, 740, the Honorable Apex Court held that bona fide requirement of a landlord over a business or commercial premises for carrying his own business due to non-suitability of the present rented space, the landlord is the best judge of his own need, provided it must be real, genuine, and bona fide, not on the pretext of enhancement of rent and eviction of the tenant. Here, I would take your lordship to a letter given by him that either you give up the premises, vacate the premises, or give me rupees 2,000 per day. That letter is also there, and my lord, that is exhibited. Bland. Go ahead. In this instant suit, the defendant witnesses have admitted that the tenancy with the plaintiff is already expired. My lord, the tenancy never expires so long the rent is being paid. And I would like to submit here, my lord, that at the time when the suit was filed, he was having rupees 5,000 from the advance in his hand. So that this observation of the learned trial court is again seems to be unwarranted. Because in the instant suit, the defendant witnesses have admitted that the tenancy with the plaintiff is already expired and commencing of a new tenancy is depend upon the option of the plaintiff. Therefore, the question of enhancing rent or eviction of the tenant is not come here in the present context, since the tenancy has already been expired, and after expiry of the tenancy, the plaintiff has the option either to commence a new tenancy or to conclude the tenancy with the defendant. Hence, the bona fide requirement of the suit premises by the plaintiff after expiry of the tenancy on 31/8/2012 cannot be termed as dishonest. The suit premises is required only after expiry of the tenancy on 31/8/2012. Hence, is considered to be genuine, and for that the plaintiff is the best judge. Now, there is another ruling, my lord, which is cited. Three more rulings are there. Mr. Messrs. Seth Nagji Parshuttam and others versus Bimal Bhai, Prabhu Bhai, and others on October so and so. Expansion of business is not genuine need. It is not the tenant who can dictate the terms to the landlord and advise him what he should do and what he should not. It is always the privilege of the landlord to choose the nature of the business and the place of business. Here, in this present suit also, the plaintiff has the privilege to choose the place of business, and the tenant has no authority to dictate what he should do and what he should not do. In view of the above discussion on the evidence led by the plaintiff to establish their bona fide requirement over the shoot premises and ratio laid down by the superior courts as regards the bona fide purpose of landlord over his own premises, this issue is decided to favor of the plaintiff. The plaintiff has established that he is in bona fide requirement of the shoot premises. Therefore, he need not to be proved any other points to get the shoot premises vacated as held Honorable High Court in Shamdasi Pal and versus Mohidun Nasa and others, 2014 5 GLR 526 decision. This issue is decided in positive. That is in the favor of the landlord. This was the finding on the bona fide requirement, my lord. Bona fide requirement. Now, my
What was
lord,
the finding of the appellate court?
on that?
on
My
that?
lord.
Because
that
this is the only contention.
Yes, that is the only condition, my lord. That your lordship will be pleased to see from the judgment of title appeal number 120, which was pronounced on 28/6/2019 at page number 87, my lord. Page number 87. The judgment starts from page number 87. Page number? Point for
Page
determination.
94.
Yeah, page 94, my lord, yes, internal page 8. Points for determination in this appeal is whether plaintiff had bona fide requirement of the tenanted premises. I have heard the learned counsels of both the parties, also perused the impugned judgment and other materials available on record to arrive at a decision on points, decisions and reasons thereof. Point number 1, that is the only point, whether plaintiff had bona fide requirement of the tenanted premises. The evidence on record, particularly the prime documents of the parties, that is the tenancy agreement dated 1/10/2007, which is marked as Exhibit 3 by the plaintiff and marked as Exhibit B by the defendant, reveals that there is a specific stipulation in clause number 3 and clause number 5C of the aforesaid tenancy agreement to the effect that renewal of tenancy shall be at the option of the plaintiff or the landlord. Now, if that be a position, then as per aforesaid mutually agreed terms and conditions, the defendant cannot claim any right to continue with the tenancy if plaintiff wishes not to renew the tenancy agreement in respect of the shoot premises, irrespective of whether defendant is willing to pay enhanced rent or not. The reason by that, the claim of the defendant to continue with the tenancy will be hit by estoppel by deed. Estoppel by deed is wrongly used by the first appellate court, by the appellate court. Appellate court. It cannot be estoppel by deed, which rests on the principle. I will explain, if your lordship desires, that what is estoppel by deed.
Yes, what is
Yes.
estoppel by?
My lord, if I have agreed to do an act and reneging from that, then the estoppel comes, that you can't go back. You can't go back. My lord, so far that those agreements are concerned, it is made by the landlord. It is made by the landlord. And that agreement, which was made in the year 2007, was valid up to the year 2012. And the third agreement was for 11 months. That was also for up to the month of November 2012. 2012. Yes, 2012.
Agreement, I did not find anywhere.
I will take you to that, don't worry. You have already submitted, no? Let me finish, then you have full chance to submit. My lord, so estoppel by deed, what I did so as to get stopped by the landlord by deed of estoppel? Nothing, nothing. Simply, moreover, my lord, so far the agreement is concerned, none of the agreements since the days of my father were ever registered. So the conditions are redundant. Only what the relation is, landlord tenant under the Assam Urban India Rent Control Act 1972, because he is my landlord in respect of a premises, I am his tenant in respect of a premises. All the conditions are redundant in that way unless the deed is registered, because the value shown over here is 1,25,000 as advance, more than rupees 100, 3,500 initial rent, which was raised from 3,500 to 5,000, my lord. So save and accept the landlord and tenant relationship, that too, with regard to the quantum of rent, all the other conditions are redundant because the deed is not registered. Deed is not registered. So estoppel by deed will not come over here. Though the learned First Appellate Court has taken this view in the judgment, but it will not come up. Which rests on the principle that when a person has entered into a solemn engagement by deed under seal with another party, he or the person claiming through or under him shall not be allowed to set up a contrary of his assertions in the deed. In other words, no man shall be allowed to dispute his own solemn deed. This was the observation with regard to that deed, my lord. So in view of the aforesaid mandate of law, the defendant oblique tenant is bound by his own agreement of tenancy to vacate the tenanted premises when plaintiff is not willing to continue with landlord-tenant relationship with him, as the agreement will bind the parties and the defendant is bound to comply with the terms of the agreement, which was created with mutual consent, keeping in view the interest of both sides. Hence, so my lord, if both side interest in the eye of the learned First Appellate Court, if both side interest is required to be kept over there, then I was having, as on that date, rupees 5,000. Why that was not considered? That was not considered at all. Because the stipulation is, my lord, that once I will tender rupees 5,000, 4,000, then 1,000 will automatically come from 1,25,000, and I am to pay only 4,000, 1,000 will get adjusted from the advance. That stipulation is nowhere considered by the learned. Trial court has considered that it is to be returned, but by the First Appellate Court. So in view of the aforesaid mandate of law, the defendant tenant is bound by his own agreement of tenancy to vacate the tenanted premises when plaintiff is not willing to continue with landlord-tenant relationship with him, as the agreement will bind the parties and the defendant is bound to comply with the terms of the agreement, which was created with mutual consent, keeping in view the interest of both sides. Hence, in view of the aforesaid provision of law, I am of the considered opinion that the defendant is liable to vacate the suit premises when the plaintiff is not willing to continue with the tenancy after expiry of the tenancy agreement dated 1/10/2007, marked as Exhibit 3. Nevertheless, for the just decision of the case, let us also consider whether the plea taken by the plaintiff that he requires the suit premises for bona fide purpose is sustainable. The word bona fide, though nowhere defined in the Rent Control Act, however, in the general context, it means anything which is genuine and real. Now, let us see whether the need of the plaintiff landlord is bona fide or not. The plaintiff in his plaint averred that he is an educated, unemployed youth having wife and a minor children, and he earned his livelihood by letting out a part of his ancestral property, which he got out of partition with co-sharers. He further averred that as the expenditure to maintain his family is increasing day by day, and rental income from the suit premises is not sufficient to meet his needs, so he has decided to run a business for his self-employment in the suit premises instead of living upon the rental amount, and for which he warned the defendant to vacate the suit premises. Now, from the aforesaid averment of the plaintiff, what transpired is that plaintiff warned the suit premises for his self-engagement and employment, particularly for running a business in suit premises so as to increase his income in order to maintain his family property. And we know that it is a settled law that when a landlord claims the property for establishment of his business or for extension of his business to increase his income, income, same come within the meaning of bona fide requirement. Aarti Saha versus Mangal Sarkar, 1995, 3 GLT, so and so. However, in the instant case, if we draw our attention to the contention of other side appellant, who will find that the defendant tenant, though did not disputed that the plaintiff is an educated, unemployed youth, and he has a family consisting of wife and children, but they took a plea that plaintiff have sufficient rental income to support himself and his family, and he also purchases a property within the RCC building in which should premises is situated, where he can't start a business without disturbing defendant, which the plaintiff, on the other hand, had denied. So let us find out what is the truth in order to decide issue in hand. From the aforesaid disputed facts wherein defendant has asserted the affirmative of the issue and insisted to believe in existence of a particular fact regarding possession of separate property and sufficient rental income. So in the light of provision of law laid down under section 101, 103 of Evidence Act, the burden of proof lies upon the defendant, tenant, to establish its claim. Now, my lord, here, other premises, because the plaintiff says or claims that he is having a 3-storied building and it is divided among his two brothers or co-sharers. Co-sharer is a brother. Co-sharer is a brother. So that 3-storied building, mine is simply a godown at the ground level, at the ground floor. So in that, if he is a co-sharer in a 3-storied building, certainly, my lord, he is having other, because he is residing also therein. He may have or might be having or is having any other place also, my lord, because in a 3-storied RCC building, two are the co-sharers. One he himself and the other is the brother. So the learned First Appellate Court has put the burden upon me, a tenant, under section 101 and 103 to establish that fact. Whereas, my lord, that co-sharer's property is not in question in this suit. The partition is also not brought to, so as I have any access to that, document to cross-examine him. So how I can prove this 101 and 103? The burden is shifted upon the tenant to prove. Whereas it is he to prove that how much property as a co-sharer he got from his brother. So instead of putting that part into the shoulder of the plaintiff, the learned First Appellate Court has put that part on the shoulder of the tenant. Whereas the very document of partition is nowhere in the suit, not brought into. And the best person to bring in was my landlord. He has not brought it. So how can that burden can be discharged by me? So let us see whether there is any evidence available on record which can establish the claim made by the defendant tenant. So when the very, my lord, this presumption or the proposition is wrong, so everything after that will be also wrong. As regards the first claim of the defendant with regard to the sufficient rental income, if we draw our attention to the evidence on record, particularly the tenancy agreement marked as Exhibit 3 and Exhibit B, we will find that tenanted income of the plaintiff from the rental premises is only rupees 5,000 per month, out of which 1,000 is adjusted against the remaining advance payment of rupees 65,000. At that time, my lord, in the second agreement, after reduction from 1,25,000, what remained was 65,000. Out of rupees 1,25,000 given by the defendant to the plaintiff during the first tenancy agreement. Now, if rupees 5,000 is taken as on actual monthly rental income from the suit premises, then a serious question arises as to whether can we hold rupees 5,000 as sufficient income to maintain a family of 3 persons in today's inflated economy? The answer, in my considered opinion, would be simply no, because the word maintenance, as we understand, does not mean only fooding, rather it includes everything to enable a human being to lead a life in dignified way. In the other word, the word maintenance besides fooding also includes within its ambit expenses for medical treatment, expenses for education. Now, instead of the learned first appellate court treating me as a tenant, he has perhaps treated me as his wife, which is totally wrong. So if that be a definition of maintenance, then I am of the view that a meager amount of rupees 5,000. My lord, there is no mention in the plaint also that I ever exercised coercion or threat or undue influence to enter into an agreement by mentioning only rupees 5,000. So in the light of foregoing discussion, I am of the considered opinion that the claim of the defendant that plaintiff has sufficient rental income is disproved. Now let us come to the second claim of the defendant, wherein he alleged that the plaintiff had property within RCC building besides the shoot premises where he can start a business without vacating the defendant. Now, if you peruse the evidence available on record, we will find that there is no iota of evidence relating to the aforesaid claim of the defendant. The evidence of the defendant is silent as to where in RCC building, other than the shoot premises, that other property of plaintiff as claimed by defendant is situated and which can be allegedly utilized by the plaintiff for doing his business. Rather, the evidence on record disclosed that the entire property wherein the RCC building is standing is an ancestral property of plaintiff, wherein besides plaintiff, his brother also has share in the property, and his brother and mother are also residing in the other part of the building. So, under above facts and circumstances, I am of the considered opinion that the second claim of the defendant is also not sustainable, and hence I am constrained to held it as disproved. Now, from the above discussion, I am of the considered opinion that both the claim of the defendant is disproved. So, the bona fide requirement of the shoot premises by the plaintiff, in my considered opinion, is found to be established. More so, clause 5C of Exhibit 3 further fortifies the aforesaid claim of plaintiff. Because if we peruse the contents of Exhibit 2 and Exhibit 3, both the lease agreement, meticulously, we will find that except clause 5C of Exhibit 3 and clause 5C of Exhibit 2, conjointly almost all the clauses are same. And if read clause 5C of Exhibit 3 and clause 5C of Exhibit 2, we will find that plaintiff from the very inception of the second tenancy agreement made it crystal clear that he is not willing to continue the tenancy in respect of the shoot premises with the defendant after the expiry of the second tenancy agreement, and for which he had brought changes in the aforesaid two clauses. And it also appears that perhaps for adjustment for balance of rupees 65,000 out of rupees 1,25,000 taken during first tenancy agreement and was constrained to enter into second tenancy agreement. So, in the above backdrop, I am foreclosed from all sides to hold that plaintiff has bona fide requirement of the shoot premises. However, the learned counsel for the defendant side, besides making above claim, also vehemently argued on two grounds. Learned counsel submitted that if the defendant is asked to vacate the tenanted premises, then defendant will lose his bread and butter, and the plaintiff is a money-minded person, and it is his hunger for money and not bona fide requirement for which he wants defendant to vacate the shoot land. Now, let us also answer to aforesaid two claims of the defendant appellant for the sake of just decision of the case. I have heard the submission of learned counsel, and as regards his first argument, it is to be mentioned that the shoot premises is admittedly used by defendant as godown for keeping the stock in respect of their two numbers of shop running at SS Road and SRCB Road respectively. And if that be a position, then I am of the considered opinion that the question of losing bread and butter by vacating the shoot premises, which is utilized as a godown, cannot arise, as because earning is done in separate business establishment, that is in aforesaid two numbers of establishments and not in godown, which is a place for keeping stocks only. And I believe the shifting of godown will not affect the business of the defendant, nor they will lose any bread and butter. So in the light of the foregoing discussion, I am of the considered opinion that the first argument of the learned counsel is not tenable. Now let us take the second argument of the learned counsel. This argument is similar to the fact averred in the WS, which has been already answered earlier, that is bona fide requirement of the shoot premises by the plaintiff. Nevertheless, for the just decision of the case, I would also like to take up this argument for discussion. The learned counsel of the defendant, in order to establish their aforesaid claim that plaintiff is money-minded, had invited the attention of this court to para number 8 of the WS and contention of letter dated 30/9/2012, marked as Exhibit E. The learned counsel argued that plaintiff at the time of renewal of second tenancy agreement, instead of enhancing 15% over monthly rent of rupees 3,500, that is rupees 525, as per their earlier terms and conditions, had enhanced 1,500. Further argued that plaintiff in his quiet notice has demanded rupees 2,000 per day from the date of expiry of the second agreement till the date of vacating the premises for occupying the shoot premises beyond tenancy agreement. And these conducts and demands of the plaintiff indicates towards the fact shows that he is money-minded person. Learned counsel further reiterates that if defendant pay rupees 2,000 per day, then plaintiff will have no objection and defendant can occupy the 1,300 premises. I have heard the submission of learned counsel of the defendant, and I am of the considered opinion that as regards the first claim of the defendant regarding the enhancement of the rent to rupees 1,500 in second agreement instead of rupees 525, I am to state that these allegations is not sustainable at this stage, as because they themselves had ratified the enhancement by accepting the second agreement. So aforesaid, the allegations of the defendant is set at rest. Here, my lord, in the first agreement, there was a clause that after the expiry of the agreement, there will be enhancement of only rupees 525 at the rate of 15%. At the rate of 15%. So if that clause is taken into consideration, my lord, then every after the period of expiry, 15% was the enhancement rate. But looking to that condition that he is not pulling on, my lord, he raised it from 525 to rupees 2,000, that is 1,500, and we accepted to that. We accepted to that. That was at that stage, my lord, it may be said to be a point which was considered by the landlord, which was considered by the tenant, that instead of raising 15%, if it is raised to the tune of rupees 1,500, my lord, 1,500, then perhaps his need will be satisfied. So the need was only the need of livelihood, not the bona fide requirement for any business, my lord, at that stage. The need was the need of livelihood, and that livelihood was survived by raising it from 525 to 1,500. Now, when he got the chance or taste of increasing instead of 525 to 1,500, then, my lord, in the second agreement, in that agreement, he made a clause that the tenancy will be renewable at the choice of the landlord. That's why the learned first appellate court is pointing out, my lord, at the choice of the landlord. And choice means if he won't agree to enhance, if he won't agree to continue with the tenancy, then according to him, the tenancy will automatically stop. And that is not the law. The law is, my lord, once a tenant is always a tenant unless evicted by due process of law. Unless evicted by due process of law. So, my advance was there, I was paying the rent. When he refused to accept the rent, then only I knocked the door of the court under section 5(4) of the Assam Urban Area Rent Control Act 1972 by depositing the rent in court. And there is no lapse on that. That's why the learned trial court, as well as the first appellate court, have not found that I am at any point of time defaulter. Yes. My lord. No, no, because my advance money is there, my lord. He cannot claim that. He cannot claim that. So, my lord, last para is that now as regards allegation regarding demanding of rupees 2,000 per day is concerned, I am to state that the conclusion drawn by the defendant from the contention of the aforesaid letter is not convincing. When the very matter is embedded in the letter, why the letter has not become convincing, that I am also not in a position to understand. I mean the view of the learned first appellate court, because the contents are there in the letter and the letter is not convincing to the court, then how that can be convincing to me? Drawn by the defendant from the contention of the aforesaid letter is not convincing, as because if we read the entire contents of the letter along with the aforesaid para number 6, we will find that no interest of plaintiff could be gathered for continuation of tenancy with the defendant by imposing rupees 2,000 per day, because the word is till date of vacating of the tenanted premises itself negates the claim of the defendant and indicates towards the fact that an amount of rupees 2,000 was demanded by the plaintiff in order to compel defendant to vacate the tenanted premises as early as possible. So, in the light of foregoing discussion, I am of the considered opinion that these arguments of the learned counsel holds no water. Hence, under above facts and circumstances, I am of the considered opinion that the suit premises as required by the plaintiff for bona fide use. Accordingly, the issue is decided in affirmative and in favor of the plaintiff. Accordingly, the judgment dated and decree dated passed by the learned
Suit premises is required bona fide.
bona fide, yes.
Though trial court gave some a different reasoning, and appellate court was mainly basing its finding on the fact that there is a termination clause in the.
Yes, that. And thereby shifting the burden upon the defendant.
Okay, now we are in a exercise of revisional jurisdiction.
Yes, my lord.
There are limitations.
Yes.
Within
Regarding
that.
the perversity.
Yes, where is the perversity?
Yes. My lord, whether a tenant can be put to the burden to prove that the premises is bona fide required by the plaintiff or not, plaintiff landlord?
Okay. So that burden is on the plaintiff.
The plaintiff. And the burden is shifted upon the defendant. And that too, my lord, on a misnomer. Misnomer in the sense that the plaintiff claimed that the 3-storied building is divided because it is ancestral property. It is divided amongst the two brothers, or in between the two brothers, together with the mother. And now, instead of that document being before the court, the learned first appellate court is shifting the burden upon the defendant to prove that the plaintiff, being the landlord, is not in need of bona fide requirement, whereas no opportunity to see and locate whether he is having any other premises or not was given to me. That document is not there. It is only on the basis of presumption. Out of these documents, my lord, exhibit.
How the plea of bona fide requirement may be proved? Suppose plaintiff takes this plea.
Yeah.
What evidence he has to adduce?
No, my lord, it is rightly pointed out by my learned friend. It is the conduct of the parties. It is the conduct of the landlord. It is not the conduct of the parties, not the conduct of the defendant, tenant. It is the conduct of the party. Now, my lord, in the year 2012.
No, my query is, your submission is that in the year 2012, when you filed your suit.
Yes, my lord.
While defending that suit, he never raised any contention.
No counterclaim was made.
No counter.
Yes.
Neither he raised any plea that the suit was bona fide required by him.
Rightly.
Suppose plaintiff filed a suit for bona fide requirement, what he has to prove? How he will, after saying that this premises is required by me, I will
For the
do
purpo-
business,
For the purpose of business.
business.
Yes. My
Apart
lord-
from that statement, what he has to prove?
Yeah, my lord, then if he is a person of, I mean, business-minded person, then my lord, he must have a petty business or he must have a trade license to do some business. That is not there. And Honorable Justice B.D. Agarwal in one of the case of this Honorable High Court, my lord, I can take your lordship to that also.
Your submission is that perversity, as regards perversity, first submission is that the appellate court held that the burden is on
On me
On
and
you.
on the defendant
Defendant.
tenant to prove that he is not having the.
he has other sources of.
Yes,
But that was observed because you took the plea that there were other sources of income.
because of the reason that he says that the three-storied building is bifurcated into two parts and his share he has got. That's why I raised that objection, my lord. Because in a three-storied building, my premises is hardly 527 square feet or 530 square feet. And the building is, my lord, three-storied. His share is half. His share is half. So that put me into an embargo to ask this question, that in that building, apart from this premises which is being run by me as a godown, you have any other premises also. Otherwise, that partition deed was not before any court, not before any court. It was merely on the basis of plea, my lord. My lord, bona fide requirement. To that query, that what other things he can show to prove that he is in bona fide need. My lord, had not be landlord and tenant eviction, bona fide requirement, plea of. Plaintiff did not indicate in their pleading the existing business of the plaintiff's firm and its partnership, including the reasons for additional accommodation, suppression of fact of letting out the building to several tenants, rejecting the plea held. Had it been a case of single tenant or of requirement of shoot premises for residential purpose, here, my lord, that was residential. In our case, it is for business purpose. The plaintiff's case could have been considered liberally on facts. Plea of bona fide requirement is rejected. Now, I would like to answer to your lordship's query that if a person is in the mood of doing the business, then, my lord, the first requirement is that nowadays, the first requirement, even in those days also, the first requirement is that he must have a trade license, he must have a GST registered, he must have his business background. He's saying that I am unemployed youth at the age of 40.
So
That
apart
employment-
from merely stating that he want the suit premises for business, he has not adduced any evidence.
Any evidence or have also not taken any plea at the time of exchange of the letters, at the time of filing the written statement to PS number 462, my lord. No counterclaim was also there to that. Had he been in a position to have the mind to run the business, then, my lord, at least that case was prior in point of time. TS 462 oblique 2.
No, he might have required it in the year 2013.
13.
In the year 2013, he might be in the circumstances where
So that's why my submission before your lordship is that the thought is not genuine. It is tainted. It's a mere desire, my lord. It's a mere desire.
mere desire means difference between mere requirement and bona fide. There was no bona fide on his part.
Yes,
That-
to act upon the desire. Desire must be in my mind, my lord. To act upon that desire must be relevant and must be shown to.
And his
be
intention was
apparent.
only to get the suit premises vacated.
That was my submission before your lordship.
Okay.
What Mr. Atal is going to submit, that is different, but that is my aim. My lord, if I can take your lordship to, though title suit 185, paragraph number 4, simply I will read, my lord. No need to turn up the pages. I will read from his, plaint, paragraph number 4, my lord. That the tenancy period started with effect from 12/8/2002 in respect of the suit premises for a period of 5 years, was over in the month of August 2007, but the defendant, instead of vacating the suit premises, requested the plaintiff to renew the tenancy for another 5 years. The plaintiff at first refused to extend the tenancy period of the suit premises for another 5 years because he was an educated, unemployed youth and he wanted to run a business in the suit premises for his self-employment, but the defendant insisted the plaintiff to give him the shoot room for another 5 years, and the plaintiff, on being satisfied with the request of the defendant, extended the tenancy period for another 5 years. Now, from here, my lord, what appears that I insisted for renewal of the tenancy on its expiry for 5 years. And at that time also he was unemployed youth, but he extended the tenancy for 5 years. Now, had there been any bona fide requirement at that stage, my lord, say at the age of 35, I have already submitted. So he should have reflected that, no, I am not going to renew the tenancy. I need the premises, you vacate it. Take the money back. Take that advance money of rupees 65,000 back. But he was not in a position to say so, and that is the reason why he extended the tenancy for another 5 years up to the year 2012. Now, another reason of doing this, my lord, because earlier, as per the clause number 5C, 15% was the enhancement which was to be put. And according to that, 525 was coming as a calculation after the expiry of 5 years to be raised in 3,500. 500 if raised, 525 if raised, it will be hardly 4,000, my lord. Instead of that, it was raised to 5,000 and he was satisfied. So his conduct was such that if the amount of rent is raised, then there is no bona fide requirement. And if the amount of rent is not raised as per his choice, then he will insist on bona fide requirement. So the desire which your lordship has asked to me, desire is not genuine, not bona fide. No? Now, one more paragraph, my lord, paragraph number 6 of the plaint, of his plaint. That the plaintiff states that the tenancy period in respect of the suit premises of the defendant was over on 31/8/2012, and as such the plaintiff on 1/8/2012 met the defendant and informed him to vacate the suit premises on or before 31/8/2012. As the plaintiff was not willing to renew the tenancy in respect of the suit premises with the defendant for further period, as the suit premises is required for his own use and purpose, but the defendant did not pay any heed to the request of the plaintiff, that on 31/8/2012 the defendant did not vacate the suit premises, nor any information was given to the plaintiff for vacating the suit premises, and as such, the plaintiff, finding no other alternative, issue a notice to the defendant on 1/9/2012, giving him 15 days time for vacating the suit premises. The said notice was served upon the defendant duly, but no reply was given to the plaintiff, nor vacated the suit premises on or before 15/9/2000. Thereafter, pleader's notice was given. Now, my lord, this 1/9/2012 letter, my learned friend has already submitted in a bunch. And we have also submitted before your lordship, 1/9/2012. This was the exhibit 4, my lord, exhibit 4. There also, my lord, there is nothing like that of that the premises is bona fide required. Desire is not at all reflected at any point of time to show that he is in real need of the premises. Virtual need may be, but real need is not there, my lord. So in my respectful submission, my lord, the first perversity that the first appellate court has put the burden on me in a revisional jurisdiction, my lord, it is under 115 of the 115 of the CPC, not 227, my lord.
Yes.
150, because there is no, I mean,
Still,
power to second appeal.
in 115 also.
Yes, same.
Yes.
It is all the same, my lord. All the same footing, yes. So, my lord, here, in my respectful submission, the first appellate court ought not to have put the burden upon the defendant to discharge that whether he requires the bona fide requirement or not. It is he who is to show from the papers and documents, as well as from the conduct, as well as from the letters of exchange, that he at any point of time requires the premises for his bona fide use. Huh? Is people ready?
Yes.
So this is my perspective.
My lord would kindly come to page 63, the judgment in 462. The judgment which the title suit they filed for not to evict without following the due process of law. Page 60, the judgment starts, my lord.
Page?
60, my lord, in the appeal memo.
Yes.
My lord, this was the title suit which was filed prior to the suit filed by me for eviction, my lord.
Yeah.
Now this is the judgment. Lordship would kindly turn to page 63.
No, this was the suit filed by the present appellant.
Yes, my lord. I'm only showing why I did not. I have prayed for bona fide requirement in the suit. The judgment is reflected by page 63, my lord. This is what I was trying to show, my lord. Only this part. That in that suit also I prayed, my lord. Para 6, my lord. Last para, my lord. Page 63. The defendant contended that he, being an uneducated, unemployed youth, is preparing to start his own business in the suit premises for his self-employment, and since he has no other alternative accommodation to run business in Guwahati except the suit premises, hence for his bona fide requirement, the plaintiff is liable to vacate the suit premises, submitting that there is no cause of action for the suit and the averment of the plaintiff are all baseless, concocted, and defendant claims dismissal of the suit. So this was there in 2012 also. The moment I filed the written statement, my lord. Second part, my lord, by not filing a counter claim, my lord, I am not debarred from filing a fresh suit for eviction, my lord. This is my second submission, my lord.
Yes.
Third part is that, my lord, even if they say that the agreement was registered or not registered, my lord, the entire arguments have come up before the Honorable Court on the spectrum of 1500, 525. The rent should have been 525 and then it is enhanced to 1500. Now, all along they have been complying this agreement. They did not raise this point of registration at the trial court. That apart, my lord, an agreement cannot be said to be executed without having the signature of both landlord and the tenant. Once both of them agree, only thereafter it is termed as an agreement, my lord. So, my lord, he knew about that. Now, my lord, best part to place on record is, my lord, comparative advantage and disadvantage, my lord. Comparative hardship, either it be the defendant or the plaintiff. that only can be equated, my lord. So on that line, I'll place one of the judgment, my lord, which says.
No,
that-
no, in a tenancy suit, if the plaintiff is able to prove that the suit premises is bona fide requirement,
End of the.
bona fide required, then the decree will follow, eviction decree.
Yes,
If he has failed to prove that the suit was, since the decree has been passed only on the ground of bona fide requirement, though appellate court has gone beyond that bona fide requirement plea also, the submission of the counsel for the appellant is that you have mere stated that it is bona fide required by you without showing any material to convince the court that how it is bona fide required. And the court, without having any evidence on record, came to a perverse finding that it is bona fide required. That is the crux of their submission.
Now, my lord, first part is that the other part of the building is residential. They could have shown that the first floor or the second floor, because it's an RCC building. It is not described first floor, second floor, third floor, fourth floor. My lord. The other part is residential only. Only two shops down below the building was there. One of my brother, other was by mine. So, my lord, he had that could have been there in his knowledge, because he is now the part of my family. He's not apart from my family, because he's having a tenanted premises at my place. So he knows about the entire building.
Yes.
So, my lord, he could have rebutted by bringing proper evidence, and I have cross-examined on those points, my lord. That apart, my lord, the two shops are there in the Fancy Bazaar area itself. One at SS Road, just below the Dynasty Hotel, and the other one is at SRCB Road.
No. Same question to you also. In your suit for bona fide requirement,
Yes, my lord.
what you have to prove to the court? How court will, apart from making a statement that it is bona fide required, what evidence you have to lay before the court so that court may come to the finding? Because the argument of perversity has been taken.
Yes, my lord.
So
my lord-
whether that evidence was there on record.
That on record, my lord, only my part is that, my lord, first part is that I had only one shop. Second part is that, my lord, at para 13 of my plaint, I have specifically mentioned that the plaintiff states that he is an educated unemployed youth having his wife and a minor child. That a plaintiff has married in the year 2005 and that he has got a child on 2010-2008. And as such, the expenditure to maintain the family is increasing day by day. By the plaintiff has no source of income to maintain his family members, and as such, he has decided to run a business. So, my lord, for his self-employment in the suit premises, the plaintiff has no other accommodation in Guwahati for running a business to earn his livelihood and for maintenance of his wife and minor children. As such, the suit premises is required for his own use and purposes. As such, a degree may be passed for ejection. So this prayer was there, my lord. And my lord, I also understood at some point of time that by this merger income, I cannot survive. That is why, my lord, in the clause at 5C, I have specifically mentioned that the option of the renewal will be at the option of the landlord. Because, my lord, the lordship would find that in the exhibits, my lord, that when I declined to renew the second agreement, my lord, by the time there was a letter from them requesting me for some more time. That is why, my lord. And since some part of the money was in my hand, my lord, by that time, so, my lord, I renewed the agreement. But it is not a case that immediately they requested me by a letter. But subsequently, I found that, my lord, my situation was deteriorating day by day, my lord. So, my lord, I immediately on the expiry of the second term, my lord, gave them a notice saying that I don't want to renew the agreement. I want my premises. My lord, a layman cannot say, he does not know the law, that he needs to write a letter writing that for my own use and occupation, I am in requirement because it was written by the plaintiff itself to the defendant that I am not going to renew the agreement anymore. Since the agreement is expiring on so and so, you kindly vacate the premises. So this was my stand, my lord. And the trial court in its judgment has, my lord, taken all such aspects, my lord. If I say that I have a minor child, my wife is there, they did not bring that key, no. Because, my lord, in order to maintain my family, because on the very same point, my lord, the Supreme Court has taken note of exactly of my same case, my lord. I'm relaxing. I'm placing the judgment, my lord. Exactly on the same point which I am making, my lord. Two 2017 5 SCC 683. Mahmood Gulshan.
Paragraph.
My lord, paragraph 4. Internal page, my lord, 4. Issue number 4, my lord.
Yes.
I'll skip out, my lord, 10 lines. Thus the question, my lord, from 10th line, I'll start, my lord. Thus the question of comparative advantage.
Yes.
Thus, the question of comparative advantage and disadvantage has an important bearing on the question of granting or refusing the relief. The question of balance of convenience or principle of comparative advantage and disadvantage will come up only when the court is satisfied that the premises are reasonably required by the landlord or any person for whose behalf the house or shop is held. But before this is to be decided, the court has to find and determine two things: reasonable requirement of the landlord or the person for whose benefit the house or shop is held, comparative advantage and disadvantage of the landlord or any person and the tenant, and these two ingredients must coexist. So what is to be seen while comparing these two aspects? We have to consider the reasonable requirement of the landlord or ejectment of his tenant. The question of requirement always differs from case to case depending on the facts of its own. While comparing advantages and disadvantages of the parties, we have to apply our mind objectively first to this aspect, whether the requirement of the landlord is real and is not a desire, but there is some compulsion that he requires the premises for his own use. It is also to be seen whether by eviction the tenant may not be put to such a disadvantage in which he cannot be compensated. So the need of the landlord must be pressing one and real. Applying this test to the fact of the instant case and taking stock of the evidence recorded by the defendant as well as the plaintiff, it is not disputed. It is also in the evidence that landlord is not having any other source of income other than the rent received through rent controller, and naturally speaking, the amount of rupees 5,000 per month is so partly amount in these hard times when every item of the day-to-day needs is so costly that hardly she cannot sustain her family. Thus, in the given situation, it is the landlord whose need is most pressing real, as in put to disadvantage in comparison to the disadvantage which would be caused to the defendant by eviction, because the machinery installed can be removed, which much case, and he can get on rent any other alternative premises in the Vim city, and that will not put to jeopardy the interest of the defendant. Therefore, the comparative advantage and disadvantage is also in favor of the landlord. So, my lord, why I am saying so? In the written statement, in the evidence I brought that he is already having 3 premises in Fancy Bazaar. 2 his shops are running. My premises only a go down. Even tomorrow, if he is evicted from that, he will not lose his bread and butter. This part I have brought in the evidence. I'll show my lord, I have cross-examined on that point. Even I have cross-examined on the point that 5C was at your, you agreed to that? Yes, I have agreed to that. That part is there in the evidence, cross-examinations. So, my lord, this is what I was trying to show before your lordship, that my my disadvantage as on today is more than the tenant, my lord. Because I am not having any other premises apart from the same. Now, my lord, the second judgment I'll place before your lordship is that the tenant cannot dictate me. Well, I've written down the citation in pencil. That is 2025 Live Law SC 1253. Para 3, my lord. Para 3, 4, my lord, are relevant, my lord, and para 5. Short judgment, my lord, recent judgment of the Honorable Supreme Court, my lord, which was authored by my lord Justice J.K. Meshwari, my lord, and my lord Justice Vijay Bishnoi, my lord. After hearing the learned para 3, my lord, page 1, after hearing the learned counsel for the parties at length, it appears that the High Court, while reversing the finding concurrently recorded by the two courts providing need of the plaintiff daughter-in-law was bona fide, went to the microscopic scrutiny of the pleadings and the evidence and reversing the revisional jurisdiction. In our view, such scrutiny in exercise of revisional jurisdiction is not permitted until the jurisdiction as exercised by the two courts concurrently is ex facie without authority, which is not a case herein. Now, reverting to the need of the suit premises as rightly discussed by the trial court and the first appellate court, it is apparent that the plaintiff sought commercial premises situated at the ground floor occupied by the defendant. The pleadings and evidence have been taken note, whereby need of the premises situated at the ground floor was found bona fide as a commercial premises. The other premises situated at the second and third floor are residential. So far as one room situated at the ground floor, it was pleaded by the plaintiff that it is residential, though commercial connection has been taken after filing of the suit in 2016. However, this itself cannot be a ground to nullify the requirement in exercise of revisional jurisdiction. In addition, the defendant proposing alternative accommodation cannot dictate the plaintiff landlord to accept the suitability of accommodation and to nullify the need by having other premises which was allegedly said to be residential and for her use a commercial electric connection was taken during the pendency of the present eviction proceeding. Now, para 5 again, my lord. In our view, this would nullify the bona fide need of the daughter-in-law of the plaintiff. In addition, as per judgment of this court in so and so, Bhupender Singh Baba versus Asha Devi, my lord, the defendant cannot dictate the plaintiff landlord regarding suitability of the accommodation and to start the business therein. In this view of the matter, in our considered opinion, microscopic scrutiny as done by the High Court in revisional exercise is ex facie without jurisdiction and warrants interference in this appeal and deserves to be set aside. Accordingly, the appeal is allowed, the impugned judgment passed by the High Court is set aside, and the judgment of the trial court and the first appellate court are restored. At this stage, now, my lord, they have taken 6 months of time to vacate the premises. That part is there, my lord. So, my lord, in the revisional jurisdiction, my lord, the scope is very limited, my lord. What he is trying to place on record was already there at the appellate stage also and before the trial court also. But the trial court and the appellate court stayed consistent. Now the material error, the perversity, the error in law, they are unable to show before the court because they went beyond in the appeal, which was also decided by the appellate court, my lord. What they could have taken, what they have taken today before this court, this was already taken in the, because if your lordship goes by the grounds of the appeal memo, my lord, in the present revision petition, my lord would find that all those grounds were there in the appellate court, my lord. And those have been taken care of, my lord. So then, my lord, I'll just place our own High Court judgment and the Supreme Court judgment, my lord. This is reported in 2018-12 SCC 576, my lord. And the judgment was authored by my lord Justice Kurian Joseph, my lord. Second page, my lord, para 43. Again, my lord, the restriction on revisional jurisdiction, my lord, para 43. We hold it as we must that none of the above Rent Control Acts entitles the High Court to interfere with the finding of facts recorded by the first appellate court / first appellate authority because on reappreciation of the evidence, its view is different from the court authority below. The consideration or examination of the evidence by the High Court in revisional jurisdiction under this act is confined to find out that the findings of fact recorded by the court authority below is according to law and does not suffer from any error of law. A finding of fact recorded by the court authority below, if perverse or have been arrived at without consideration of the material evidence, or such finding is based on no evidence or misreading of the evidence, or is grossly erroneous, that if allowed to stand, it would result in gross miscarriage of justice, is open to correction because it is not treated as a finding according to law. But however, my lord, that part is missing, my lord. Why that is perverse, my lord, that nothing has come on record, my lord. Because whatever they have pleaded, my lord, everything was there. And it was rightly taken care of, my lord. One more, my lord, our High Court judgment, my lord, authored by my lord Justice P.K. Dekka, my lord. That was reported in 2000. Yes. So, 2019 1 GLT, my lord, page 221. Here, this court has also taken note of the fact that, my lord, in divisional jurisdiction, para 9, my lord, the same judgment which was shown by me, my lord, in the preceding judgment, my lord, the same aspect at para 9, my lord, the same part has been taken, my lord. Last 5 lines in the third para, my lord.
Yes.
In the second para, last above 4 lines, my lord. Revisional power is not and cannot be equated, my lord. Has my lord found that, my lord?
Yes.
Revisional power is not and cannot be equated with the power of reconsideration of all question of fact as a court of first appeal, where the High Court is required to be satisfied that the decision is according to law. It may examine whether the order impugned before it suffers from procedural illegality or irregularity.
Okay.
So rest, my lord, as far as the pleading part is, everything they have shown, my lord. If your lordship, my lord, I have already filed the exhibits, my lord. The cross examinations are there, my lord. The exhibits are there. Everything is there, my lord.
Any reply?
My lord, not in the form of reply. My learned friend is saying that the revisional court has a limited jurisdiction
Yes.
and cannot alter the decisions of the, I mean, either the trial court or that of the first appellate court. My lord, here, at page number 47, which I have already shown to your lordship, at page number 47 of the trial court judgment, that a cost was imposed by the trial court. My lord, on the contrary, the law is that whenever a landlord desires to evict a tenant, then in that case, he must follow the due procedure of law. So there was no negligence on the part of the tenant either to invoke under section 35A to get a cost or under order 20. Sorry, yes, order 20A, my lord. But yet the cost was imposed. We made that observation in the appeal. The learned first appellate court has not touched even that point. Whereas the learned trial court has no jurisdiction to impose a cost upon the tenant when the law is, my lord, established principles of law is that if a landlord desires to get his premises vacated by the tenant, then in that case, he must follow the due procedure of law. When he has followed the due procedure of law, and I have replied to that, then there was no lapse on the part of the tenant so as to impose a cost. So that there is a perversity in that way. Yes. Second, my lord, submission is, my respectful sir, that the first appellate court has taken or has gone further by saying that it is the tenant who is to prove.
Yes, that you have submitted.
Yes, that I have submitted. So
Shifting of burden.
exactly, my lord.
Okay.
So this is my
Only last submission, my lord. My.
No, we have to
Oh,
stop at
one minute, one minute.
some
I-
point.
I'll-
What you want to submit?
No,